What's that humming noise?
All jurors present in the courtroom.
All right. Members of the jury, good morning. Please have a seat. Well, welcome to State of Florida versus Preston Lloyd Brewer. Good to see you all here in a timely fashion again this morning. Thank you very much. As you recall, we adjourned a little early yesterday. Both sides had rested their case, and I told you that I needed to take up some matters with the lawyers that would take a little bit of time and really wasn't for your involvement. You just have to wait around. So we took care of what we needed to take care of, and so now once again the lawyers and myself are ready to address things right directly to you all. So I'm going to read you an instruction and then you'll hear closing arguments. So, ladies and gentlemen of the jury, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. So, counsel for the state, are you ready to make closing?
Yes, Judge, I am.
All right.
Thank you, Your Honor.
All right.
Defense counsel, Your Honor, ladies and gentlemen of the jury, good morning. First of all, let me start by thanking you for your patience over the last week and a half as we have presented this case to you. I know it's been a long process. We appreciate your time, your consideration, and most importantly, your attention to this matter as we presented the evidence in the state of Florida versus Lloyd Brewer. Now, let me just start a little bit about what you've seen over the last week, or the last couple of days at least. You've all heard the phrase senseless killing, right? Everybody's heard that phrase before. I submit to you, there is no case that more embodies that phrase than this case. A senseless killing. Garrett Hughes was murdered by this defendant for urinating on a wall. That's what he did. And what happened back on February 13th of 2023? What happened? Well, we know what happened because you heard from the witnesses who were there the night of the shooting. You heard about these four young guys, two brothers, two friends, Carson and Garrett, the brothers, and their friends Logan and Blake. Super Bowl Sunday, everybody's having a good time, went to a family party, and they're young guys, they didn't want the party to end. So they decided to go on down to Conchtown, throw some darts, maybe have a few more drinks, shoot some pool, get some food, hang out a little longer until it was time to call it a night. You heard they walked to Conchtown. They'd all been drinking, so nobody got behind the wheel of a car. A friend actually found them and picked them up and gave them a ride halfway and got to the Conchtown. And we know they got there, and we know they were there because we talked to Ashley, the bartender, and we saw video from Conchtown. And we saw the young men inside Conchtown getting their drinks, eating food back by the dart room, shooting pool, having a good time. And you heard from Ashley that there was no interaction between these young men and this defendant inside the bar that night. And we know that's true because we watched video and you saw several times they actually crossed paths with each other. The defendant was sitting at the bar, they walked right past him. There were no words exchanged, there was no existing beef, there was nothing going on there that indicated any level of beef between these two parties. And we know that's a fact because Carson testified to it, Logan testified to it, Blake testified to it. They didn't know him. Matter of fact, they were surprised to watch the video, right? And they said, oh yeah, we didn't even realize that, him. What they didn't realize was what an impact that defendant sitting at the bar was going to have on their lives. They hung out in Conchtown for about an hour. Everybody was consistent with that. And afterwards, they decided to leave. And they went out the back door to the parking lot behind Conchtown. And Garrett decides he's going to urinate on the building across from the parking lot. And you heard Carson say, "We've done it. Everybody's done it 1,000 times." Listen, is it a great thing to do? No. Is it hygienic? No. Does it happen? Yes. All right, it's one of those nuisances. Probably not the greatest thing, but it is what it is. So Garrett heads over to the wall while his brother and his friends kind of wait for him right by the door outside of Conchtown. Defendant leaves. Now, we know the defendant left, we know why he left, because he told the Detective Valle, "Yeah, I went back there to see what those guys were doing. I wanted to make sure they weren't up to something. I'd had some problems in that parking lot in the past, and we've been working on these drug dealers or whatever." And he even said in his own words, the defendant said, "Yeah, I don't think they were doing anything like that. They weren't doing anything like that." But we know he was in a mood. We heard Ashley say, yeah, he was in a mood. The more he drank, the darker mood he got into. He was being a little difficult about them running out of the IPA that he likes. He was being kind of rude with her and demeaning to her when he suggested that he was just going to stick around and stare at her because she was something good to look at. He was in a mood. I think Ashley said a dark mood. And it got darker the more he drank. And remember, we know that he was intoxicated because 7 hours after the shooting, during a 7-hour stretch, when no alcohol was provided to him, he was still at a .111. Still about 1.5 times the legal limit if you were going to drive a car. So use your common sense. Where was he at 7 hours before on the alcohol meter? I submit to you, he'd have been higher than that. He's in a mood, he's been drinking, walks out the door of Conchtown, and right then, ladies and gentlemen, right then is when this event starts. And it's important for you to understand that. When he walks out of Conchtown, as soon as he hits the parking lot, this event starts. This was not a knee-jerk reaction to a 3-second exchange with Garrett. This was not a impetuous, spontaneous, whatever word you want to use, reaction to what he saw. It was a prolonged exchange. It wasn't hours, but it wasn't seconds either. The minute he walked out of Conchtown, he looks over, he sees Garrett urinating on the wall. Video shows it, witnesses testified to it. And he gets angry. He gets annoyed. And how do we know that? Well, we see him walk out there, and he gets out past the Jeep, kind of in the center area of the parking lot, and he does this. This is the international sign for what in the hell is going on here? He's thinking. He's processing what he's seeing, and he doesn't like it. And he turns around, and the boy said that he seemed agitated. The boys that were standing right outside, and I call them boys because they're young men, but they're standing right outside the exit from Conchtown, and after the defendant scratches his head, he kind of walks back over where the guys are, and then he stops. It's like in his mind, no, I'm not letting this go. Turns, puts his hand back here, makes sure his weapon's on his hip, pulls his shirt up a little bit, and he begins that deliberate walk towards Garrett. It was not a saunter. It was not a casual glide. He walked with a purpose towards where Garrett was. Garrett's still urinating on the wall. As Brewer's walking across the parking lot, he starts to exchange words with Garrett, back and forth, back and forth. And Brewer says to the detective, yeah, I'll be honest with you. I told him, why the fuck can't you piss in the toilet inside Conchtown? He's mad because Garrett is urinating on the wall. Can't let it go. And Garrett is yelling back to him, who are you? Who are you? What the hell? And at some point, Garrett finishes up, zips up his pants, turns around, and comes off the wall. And when he does that, Brewer stops. He's about 18 feet away at that point. Brewer stops, and he pulls that firearm. I submit to you, he was contemplating what he was going to do, and at that point, he pulled that gun. And ask yourselves this, why? The urination was over. What was the confrontation going to be about at this point? If you wanted him to stop urinating on the wall, he stopped. He was done. He turned. He was over. It was over. Okay, I urinated on the wall. I'm done.
Mr. Mansfield, I hate to interrupt you, but this microphone over here keeps knocking against.
Oh, I'm sorry, Judge.
The side, and maybe.
There we go. I think that'll be better. Part of it's me, Judge, banging the podium. I'll try not to be so.
No, it's okay.
Okay. Okay. Now it's gonna, I've never needed the mic. At any rate, the urination is done. He's done with it. So why a confrontation at this point? Why not just let it go at this point? Brewer wasn't gonna let it go, because at that point, he decided Garrett Hughes is gonna pay for what he did here. Not letting this go. He's about 18 feet away. What is that, 5 yards in a few feet? I always liken it to a football field. So we're looking at about 5 yards. They're not right on top of each other. They're a good distance away, but he's got that gun drawn on Garrett. Garrett's trapped at this point. He's got a car on either side. He's got a wall behind him. His only exit from that makeshift cage that he was in was through the defendant's side, and the defendant was blocking that with a gun held on him. So at one point, you'll see in the video, and you saw it already, the defendant kind of steps to his left, and Garrett steps to his left. So you got these two guys who are kind of facing each other. Now, they each kind of step to their lefts, which creates a path of exit for Garrett. And you can see Garrett start to walk towards that path of exit. And what happens? Garrett's not walking away from this. The defendant has decided that. He's not walking away from this. So the defendant, as soon as Garrett starts to step towards that exit path, the defendant comes immediately over to him, bum rushes straight over to where he's at, and engages him. Face to face, engages him with that gun still drawn on him. Now, the defense is going to get up here and argue, oh, well, he had a bottle in his hand. He had a bottle in his hand. It's hard to see in the video. It looks like he grabs for something. And we know that before he urinated, he set his beer down on top of that car. Garrett's also very inebriated. I submit to you, when he's done, his thought is, let me grab the beer that I left there and leave with it. Whether there was beer left in it or not, I don't know. It doesn't matter. But in his mind, he retrieves the beer. Now I submit to you, grabbing a bottle and holding it like this is not a deadly weapon. If Garrett had cracked the bottle open, wheeled it over his head, or like this, with a broken base on it, now we've got a deadly weapon, but there's no evidence of that. There's no evidence of that. Garrett's not armed with a deadly weapon. But now, when he tried to walk away, the defendant stopped him. What's in the defendant's head? I'm taking this kid down. I'm going to take this kid out. He's disrespected me. He's disrespected my parking lot. And remember, Brewer doesn't own that building. He owns the parking lot. Didn't own the building that Garrett urinated on. So I guess, the urine on the parking lot was something he had an issue with, and Garrett had disrespected him, and Garrett was going to pay for that. They exchange a brief struggle over this gun, and the gun goes off. It's not an accidental shooting. You heard the defendant tell the detective, oh no, there's no question I shot him. He was just on me so quick. He wasn't on you quick, you were on him quick. You rushed him. He didn't rush you. Oh, he was on me so quick, the first shot went into him, the second shot went in the air. It was not an accidental shooting. He knew he popped off 2 rounds on that gun. Oh, he was coming at me. Ladies and gentlemen, who had the beef and who took the beef? Garrett Hughes did not go to where Brewer was with the beef. Brewer had the beef, and he took his beef over to where Garrett was. He took his fight to Garrett. And he puts that gun on him. They struggle over the gun goes off. That's deadly force. Now, we know Garrett tried to swipe the gun away. Testimony told us that. Witnesses told us that. And the DNA expert said, well, I did find his DNA as a mixture on that slide. Certainly would be consistent with him trying to swat the gun away. Also could be consistent with the gun being pressed into the abdomen of Garrett. He was bare-chested, no shirt on. So the DNA analyst said, yes, that would have also been consistent to transfer his DNA from his chest area onto the slide at the time the gun was pressed into his torso. And you heard Dr. Steckbauer tell us yesterday that it would have taken some force to push that gun into the torso. It wasn't just a light shoot. It was, you had to press it in and pop off that shot. There was no stippling, and there was a muzzle burn, which indicated a contact shooting with significant force to hold the gun there. The gun being held by the defendant, the gun that was fired by the defendant. You saw Garrett's outfit yesterday. Underwear, shorts, and flip-flops. Where's his threat? Where's his gun? Where's his weapon? He didn't have one. There was no place to put it. Senseless killing. But the defendant made that choice. These are choices he made, which puts him in this courtroom today. He chose and he decided that Garrett was going to pay a price for that, disrespecting him in his parking lot. I'm the owner. I own it. You're not leaving. You're not leaving. Defense is going to get up here and talk to you a little bit about, I'm sure, the witnesses that you heard from, Carson and Logan and Blake. And I submit to you, these boys have been consistent. They have been called upon to testify over and over again. First, they had to explain to the police officers what happened. Sure, they had to explain to their families what happened. They had to give sworn statements to the police officers. They had to come in and give a deposition. They had to come in for pretrial hearings, and they came in for trial. Time and time and time again, they have been forced to relive what is arguably probably going to be the worst day of their entire lives. And they were consistent. They were never impeached, meaning their details were consistent. Were there any major inconsistencies in what they testified to? No, there wasn't. Defense will say, well, they're biased witnesses. You know, they know Garrett was their friend, their brother. Okay, let's talk about Melissa Roberts. You remember Melissa? She just happened to go out in the parking lot that day. As dumb luck would have it, she's having a cigarette and she sees this unfold before her eyes. And you saw her on the stand. And you saw the emotion that she brought to that testimony. She has been impacted by what she saw. She was crying. She was still upset. 3 years later, it brings tears to her eyes because, in her words, Garrett didn't stand a chance. And she said that boy wasn't doing anything. He wasn't presenting any threat to this defendant, and this defendant shot him. She's not aligned with any party. She's not affiliated with the Garrett or the Hughes family or the Brewer family. She's just a lady who was in the parking lot with her dog having a cigarette when she saw what she saw. And I submit to you, that might be the best witness ever. She's not biased, she's not tainted, and she knows what she saw. And she came in here and told you what she saw. Ashley, the bartender, kind of set it up for you, so you knew what was going on in the bar that night. All this talk about a bottle And the defendant's statements to the police officer when he says, oh, there's no doubt I shot him, there was no mention of a bottle. There was no mention of, hey, he had a bottle in his hands, he was going to attack me with it. You didn't hear any of that. What you heard him say was, I think he was reaching for something. What's he reaching for? He's got a pair of shorts on and flip-flops. Ashley came in. She told you what she saw in the bar. Miss O'Neill came in. She told you about how DNA is done, and you got a nice lesson on how DNA is extracted and tested, analyzed, and interpreted. You heard from Dr. Steckbauer yesterday, our medical examiner in this jurisdiction, who told you what his results were. He was able to hold the gun right up and show you the muzzle burn matches up to that firearm completely. And you heard from the detective, who was specifically requested by this defendant to come down and talk to him so he could tell him what happened. That's what we presented to you over the last 4 or 5 days. And I submit to you, what we've presented to you is first-degree premeditated murder. It's what it is. It's ugly, it's terrifying to even think about or to say, but that's what the defendant did that day. At the end of this trial, you're going to get a packet of instructions from the court. It's all the law that pertains to this case. Didn't even have to go to law school. You're going to get everything you need. The judge is going to give you a packet of instructions. He's also going to read them off to you before you go into the jury room. But here's all the law that pertains to the case. And I want to take you through a little bit of it just to kind of give you an idea of the process that you'll be going through when you get to the jury room and start to analyze what you've seen and how it relates to the elements that we have to prove. So let me go over here. Okay. Oh, no, I know. Oh, yeah. Carlina's been teaching me about PowerPoints, so I'm getting real good at it. No bells and whistles, but the basics are there. So let's talk about it. We charge the defendant with first-degree murder because that's what he's guilty of. To prove the crime of first-degree murder, we have to prove 3 elements. First, that Garrett Hughes is dead. Well, there's no question about that whatsoever. The death was caused by the criminal act of Lloyd Brewer. He admits to pulling the trigger. He's the one that shot the gun. Number 3, there was a premeditated killing of Garrett Daniel Hughes. Premeditation. What does that mean? Well, let's talk about it. First of all, if you go back here, you see the word act in element number 2. You're going to get a definition for that. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. It's not just the act of pulling the trigger. It's a series of acts, and I submit to you that series of acts started the minute Brewer stepped out of the door of Conchtown. That's when the series of acts started. It's not just the pulling of the trigger. It's not just the confrontation. It's the entire episode. That is the series of acts. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. From the minute Brewer stepped out of the bar, he was contemplating, he was thinking, he was watching, he was processing, he was already thinking. And by the time he got across the parking lot and drew that gun, he knew what he was going to do. Garrett was not walking away. And how do you know that? Because when there was an opportunity for Garrett to walk away and a path of exit, the defendant blocked it. That's how you know what his intent was. Garrett wasn't walking away from this. Did he have time to reflect and contemplate? Yes. Consciously deciding to do so. The law does not fix the exact period of time. The question of premeditation is a question for you to determine. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt that premeditation existed. I submit to you, we've proven that it did. We've proven that it did. He was going to kill Garrett Hughes for the disrespectful act of urinating on the building in his parking lot. Wouldn't let him leave. Garrett had no choice. Or as Melissa Roberts said, Garrett stood no chance at all. Colleen, I need to play it. Please. Thank you, ma'am. Premeditation. Look at already contemplating, reflecting, thinking. Still contemplating, still reflecting, still thinking. Nope, nope, I can't let this go. Nope, nope, got my gun. Nope, I'm gonna head over there and take care of business. Now look at Garrett. Garrett's done. He's done, he's walking away from it. Or so he thought. Oh, let me grab my beer. Now the gun is drawn, you're not leaving. Step to the left, Garrett wants to walk out, come back over, confront him. There's our friend Melissa. She hears the gunshots. And there you have it. There's your premeditation. He's thinking about it the entire time. I gotta come in. Yeah, I watched you.
Swipe spots in your hand for the GSR?
I don't deny that I shot a firearm.
Doesn't deny he shot the firearm. We know he shot it. He doesn't say, oh, it was an accidental shooting. It went off, which I shot the firearm.
I'm gonna do.
Now, I submit to you that's what we've proven, and that's the evidence that you've seen in this case. However, you're going to be instructed that you have an option, and the court's going to tell you that there's such a thing in the law called a lesser included crime. What does that mean? I liken it to like a dollar bill. 70 cents is less than a dollar bill, but it's part of a dollar. Well, second-degree murder is a lesser crime of first-degree murder. It's still a crime. It's just not first degree, it's second degree. It's a lesser included crime to the crime of first degree murder. And if, for some reason, you don't feel that we've proven first degree murder, you will be able to consider whether the facts have proven second degree murder. And let's talk about second degree murder. To prove the crime of second degree murder, we have to prove the following three elements. Garrett Hughes is dead, we know that. Death caused by act of Brewer, we know that. Number three, there was an unlawful killing of Garrett Hughes by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Well, certainly pointing a gun at somebody and firing it is an eminently dangerous act to another. And what was Brewer's mindset at the time? Angry, annoyed, irritated, dark mood, pissed off about the urinating on the wall, demonstrating a depraved mind without regard for human life. You'll get some definitions. Again, an act is a series of related actions, and again, I submit to you, this entire event is a series of actions. It's not just one specific act. The act is imminently dangerous to another, and it demonstrates a depraved mind if it's an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury. Firing a gun at someone's torso, I think a person of ordinary judgment would know that's going to hurt, whether it kills or does serious bodily injury. It's done from ill will, hatred, spite, or evil intent. Well, we know he had ill will. We know he had spite, the defendant, because Garrett Hughes was urinating on a wall. And the act is of such a nature that the act itself indicates an indifference to human life. That's exactly what Brewer had, an indifference to Garrett Hughes' life. In order to convict of second-degree murder, we don't have to prove that he had an intent to cause death. But he had ill will, hatred, spite, or evil intent, and he knew the act would kill. I threw this slide in here. You're going to get this. You've heard all about our burden is a reasonable doubt. You're going to get a definition for it. It's not a speculative doubt, imaginary or forced doubt. Keep those words in mind. We don't have to prove it beyond all possible doubt. It's beyond a reasonable doubt. Your common sense will tell you what's reasonable. But there's your definition for reasonable doubt, and you'll have that when you go to the jury room. You're also going to get an instruction about, it's basically what we call the self-defense instruction. Was this a justifiable use or threatened use of deadly force? It's a defense to the crime of first-degree murder or even second-degree murder if the actions of Mr. Brewer constituted the justifiable use or threatened use of deadly force. Deadly force, we know firing a firearm is clearly deadly force. Great bodily harm means great is distinguished from slight. A firearm is by definition a deadly weapon. The defendant doesn't have to prove that he was justified in using deadly force. We have to prove it, that he was not justified. And I submit we've proven that. Justifiable shooting against what? A man in a pair of shorts and flip-flops? What force is presented against him that he would have been remotely justified in that confrontation? The force, if Brewer was justified in using or threatening to use deadly force, if he reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to himself or a commission of an aggravated battery against himself. Again, there's no evidence in this case that supports either one of those findings that would have made it justifiable for this. What imminent death or great bodily harm did Garrett Hughes, who was, 3 times over the legal limit, what threat did he present? If he was not committing any other crime than first-degree murder, for which he's claiming self-defense, and he was in a place where he had the right to be, he had no duty to retreat. Fair enough. However, on the other hand, if at the time he used this deadly force, he was committing an aggravated assault with the firearm, holding a gun on Garrett Hughes, aggravated assault with the firearm. If at the time he was committing an aggravated assault with the firearm, then he did have a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using or threatening to use force. Because he pulled that gun on Garrett Hughes, because he put him in fear of being shot, that's an aggravated assault with a firearm. And because because Brewer was committing a crime at the time, he had the duty to retreat. He did not retreat. Not only did he not retreat, he prevented Garrett Hughes from exiting. The law would not require the defendant to retreat if by retreating it would put him in imminent danger of a crime against himself, and retreating would have increased his own danger, or if the retreat would have been futile. Neither of those applies here because all he had to do was walk away. Walk away. Walk away, Brewer. Garrett Hughes lives to see another day, and so do you because you walked away. The law said you had to, but you didn't. First-degree murder. When you decide whether he was justified, you have to consider the circumstances at the time the force or threat of force was used. The danger need not have been actual, but to justify the use, the appearance of imminent danger must have been so real. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed force was necessary. No reasonable person or prudent person in that scenario would have felt that firing that gun and killing Garrett Hughes was necessary. However, the use or threatened use of force is not justified if Preston Brewer used force or threat of force to initially provoke the use or threatened use of force against him. The use or threatened use of deadly force is not justified if you find that he, the defendant, used force or threat of force to provoke the use of force against him. That's exactly what he did. He provoked Garrett during that physical altercation when the defendant rushed over to Garrett and confronted him physically. He provoked him. Now, the law tells you the use or threatened use of force is not justified unless the force toward the defendant was so great that he reasonably believed that he was in imminent danger. What force? There was no force against him. And number two, in good faith, the defendant withdrew from the contact, and Garrett Hughes knew he was withdrawing, but continued or resumed the use of threatened use of force. First of all, Garrett Hughes did not use or threaten to use force against Brewer, and Brewer certainly didn't withdraw from the physical altercation. He commenced it, he pursued it. Again, Garrett Hughes was not walking away. Once that gun was drawn, Brewer's mind was made up. This kid's going down for this. In considering self-defense, you can consider the relative sizes of the two men involved. One of the instructions you're going to get is obviously you're going to have to weigh the evidence. It's going to be up to you how much weight you want to give the evidence, but you should consider how the witness has acted, and here the law gives you some things to consider. Did the witness seem to have an opportunity to see and know the things about the witness, about which the witness testified? Well, Carson, Blake, and Logan all certainly were right there when it happened, and so was Melissa. Did they all seem to have an accurate memory? Nobody was impeached. Were they honest and straightforward? I submit to you they were. Did they have some interest in how the case should be decided? Defense will tell you that Carson Hughes did, so did Blake and Logan. That was their friend, their brother that was killed. Melissa Roberts didn't. Does the witness's testimony agree with the other testimony? Video evidence supported the testimony supported the video evidence. Did the witness at some time make a statement as inconsistent? Nope. And we heard Melissa had a felony in her past. I think that's all I had. So at the end of the day, ladies and gentlemen, your job is not easy. I'm not going to sit here and tell you that it is. But in this case, the evidence is overwhelming that on February 13th or early morning of February 14th of 2023, this defendant, while in an agitated, irritated mood, made the decision that Garrett Hughes was going to pay for his life for disrespecting him in that parking lot. Garrett Hughes was done urinating. All he wanted to do was walk away. And this defendant wasn't going to let that happen. He blocked him from leaving. He engaged him. He shot him. And he did this after time to reflect on what he was going to do. When you go back to that jury room, don't be afraid to say, you know what, Mr. Brewer, what you did, it's not acceptable. You committed a premeditated first-degree murder when you killed Garrett Hughes, and now you have to be held accountable and find him guilty. Thank you for your time. Judge, at this time I have nothing further.
All right, thank you. Members of the jury, you've just heard the state's first closing argument. Now the defense counsel is going to have an opportunity to make his closing argument, but I'm going to take a quick break, 10 minutes, to allow counsel for the defendant to set up and get things organized. So If you'd go in the jury room, it's going to be 10 minutes. We'll be back out here at 10 o'clock to hear defendant's closing. Thank you. Didn't want to interrupt you, but that mic kept banging against the side of the podium, and I think it was kind of annoying. So I don't know if Mr. Bellarado wants to readjust it, or if it even...
It's just don't shake, when you shake when they move the podium, it moves.
All right.
Because I'm not typically a podium thumper, I'm a Catholic, you know, we don't really do that, but I mean, so here's the modifier.
All right. Thank you. All right, so this is the modified instruction. So has defense counsel, Mr. Canizar, this is the modification. Again, I know you objected, but this is the one I ordered. The state presented to me. I want to be sure that you agree that it's what I said I was going to do. Again, I realize it's not what you wanted, but is that consistent with what I said? Thank you. All right, so during the, right at the end, or before we took the break, state brought to the bench the latest revision of 3.6. I wasn't going to say anything about that, but we're not going to get hung up on that. But I did show it to Mr. Cannizzaro, and he did indicate that it's consistent with what I ruled, preserving their objection, but, so I've inserted that in my package. You ready? Okay. So we'll bring in the jury then.
I'll just need a minute after his. I won't need more than a few minutes just to switch over.
Do you need a break, or do you just?
No, I won't need a break, but I'll just need a minute to put.
Yeah, okay, but they can,
I will not need a break.
okay, so we can keep the jurors in place. All right. Thank you. Please be seated, members of the jury. Welcome back to the courtroom. Thank you for your patience. Before the break, you heard state's first closing, took a break, and now counsel for the defendant has an opportunity to present his closing argument. Mr. Bellarado?
Yes, thank you, Your Honor. Good morning, ladies and gentlemen. You know, don't say I didn't warn you. I told you at the end of my opening statement that I would be back. And I am back. And I'm going to make my best efforts to try to address some of the accusations made in the charges and the indictment and the accusations made by the prosecutor during the course of the presentation of the evidence and the statements that they've made during the closing argument. If you remember, when I made my opening statement, I really tried to avoid telling you anything about how you should decide the case. I tried to avoid telling you that, well, this is what you're going to see, that's what you're going to see, because I wanted you to decide for yourself. I wanted you to see what was here. If you remember, when the prosecutor opened their case, didn't say anything about the bottle. You know, the only person that had a weapon was Preston, when in fact that's not what happened at all. Now they've embraced the fact that Garrett had a bottle, that Garrett took that bottle with him and put it on the top of that car, that he turned and picked up that bottle after Preston approached him. But we'll get into that in detail because we really need to look at the video and you'll understand really what happened. I'm going to try to answer all your questions. You know, it's a phenomenon of the American judicial system that the lawyers stand here and tell you what they think. It's not evidence, but we tell you how you might look at the evidence. But you don't get to ask any questions. You know, in some jurisdictions in other countries, the jurors actually get to ask the finders of fact, sometimes jurors, sometimes judges, really get to ask the lawyers questions during this time period. But that's not the way it is in the United States. So we try to anticipate the questions that you might ask, and I'm going to do my best to answer all your questions to assist you when you do your deliberations in the jury room. Remember, always, that we have no burden to prove. We don't have to prove self-defense, we don't have to prove anything. They have to prove that he wasn't entitled to self-defense, they have to prove each and every element of any one of these offenses. And I'm not going to put them up again, you saw what the prosecutor put up, I'm going to mention some of it to you, but they have to prove each and every one of these elements beyond all reasonable doubt. Judge will give you what that means, but I'm sure you can understand that it's a very high and a substantial standard, all right? You must be convinced beyond all reasonable doubt. They have the burden to prove that Preston is guilty of these offenses in each and every one of the elements, and there's a presumption of innocence, and it's an important presumption, and that is Preston is not guilty
of these offenses, and only can be guilty if you find beyond the reasonable doubt, all reasonable doubt, that he committed these offenses. We are a nation of laws. You know, we're not a nation of status, you know, we're not a nation of emotion. We are a nation of laws. That's what governs everything that happens here. I think the judges reminded you of that a couple of times during the course of the presentation, and it's true. And you will see that at the end of our closing arguments, the judge will give you the law, and that's what you're bound by. You can make findings of fact, that's solely your province, but the law will be given to you by the judge, and you'll have a clear understanding of the course that you need to take to arrive at a decision of guilty or not guilty. And I suggest to you that you will see that the state has fallen woefully short of proving these elements of these offenses beyond all reasonable doubt. For example, when you get to look at the charge again, the law for first-degree murder, it doesn't necessarily talk. I mean, it talks about the act. The act is important, okay? It's the homicide, that somebody is dead, yes. But the whole essence of the charge is the mental state, is what's in the actor's mind at the time. You know, it's a thing that's called in the law called the mens rea, the evil mind. And that's what's necessary. Because if you look at the first-degree murder, and it talks about, you know, somebody has to be dead, it has to be caused by a criminal act, which I suggest we don't even have here, and it has to be premeditated. Right? That's a really important statement. And in the definition, I'm not going to give you the whole definition, but you'll see it when the judge gives you the charge, and you saw it up on the screen. Killing with premeditation is killing after consciously deciding to do so. Consciously deciding to do so. That's what murder one is. And murder two, even the second-degree murder that you're going to be charged with, says that there was an unlawful killing of Garrett Hughes by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. And they define that, and they said, is done with an ill will, hatred, spite, or an evil intent. Indifference to human life is of such a nature that the act itself indicates an indifference to human life. I suggest to you that what we saw here, while a tragedy, no question about it, doesn't fit either one of those definitions, no matter how you look at it. So I'm going to take a few minutes and I'm going to discuss with you some of the information and some of the evidence that we saw in this case. The case took place over a very short period of time. Before I sit down, we're going to look at two videos. They're going to show you exactly what happened that night from two perspectives, and I suggest that you'll see exactly how this happened. And there's a reason why it happened. And it wasn't because Preston stood out there to kill this kid for peeing on the wall. It's like the most ridiculous thing I've ever heard of. He went out there because he wanted to kill this young man merely because he was peeing on the wall. I suggest to you that's not what the evidence demonstrates. And the prosecutor can say it 100 times if he wants. It doesn't change what really happened here and why it happened. You know, they tried to dress this case up, right? They put Melissa on the witness stand and they put Ashley on the witness stand. Why? They put Ashley on the witness stand. Preston was in a bad mood that night. He was dark or angry. And Melissa, you heard the description that Melissa gave. And Melissa was in there a total of 5 minutes. Most of the time, when she went in, Preston wasn't even in there. She saw him for a couple of minutes. She didn't even talk to him, had no interaction with him, but she took the witness stand under oath and said, oh yeah, he was really bad. He was really in a bad mood. He was really, not friendly to anybody, and it was really not good. That's Melissa, Melissa, look. Melissa, the government, they put her on. She's a convicted felon, all right? They put her on the witness stand, and she testifies, and she lies. She flat out lied to you. There's just no question about it. She said, when she was asked questions by the prosecutor, Oh, Garrett didn't have anything in his hand. And then the prosecutor sits down, lets that go. It's clear she knew different. It's clear that on an earlier time, I said to her, didn't you previously say that you saw Garrett with the bottle in his hand? And she says, oh, yeah, that was when he just was drinking the bottle when he first came out. That's what she tried to walk it back, tried to say that. That wasn't true at all. Why? She wasn't even there then. She was in her car then. She didn't even see what happened until she saw the last couple of seconds of the incident. She didn't see really what transpired. She didn't hear anything that was going on other than the guy screaming and yelling. She didn't know what Garrett was saying to Preston. She had no idea. She did see the bottle. Then I said to her, no. That's not what you said when you were interviewed previously. I said, what you said previously was that he was just pulling his pants up and all he had was a bottle in his hand. Oh, yeah, that's right. So he had the bottle when he was at the wall. Yeah. She lied, and she thought she could get away with it. I suggest to you that when somebody, a convicted felon like that, when somebody lies to you like that, there's no reason to believe anything that she says. Besides the fact that there was no basis for her to say anything about how Preston was behaving in the bar. Let me take a second and I'm going to show you. This is, you'll forgive me if I don't do this right. Okay. I'm going to play this clip for you. It's not coming up. There's nothing here, Mark. Can you give me a hand for a second, please? Excuse me, Your Honor. Let me see if I can.
Okay.
There's nothing coming up there. I know. It's up there. Okay. All right. Thank you for being patient, please. This is Preston going in the bar. That's Ashley. Watch the interaction. Now, this person over here is Eve Medley. I guess she's talking to, I don't know who she's talking to. But watch this. Watch what happens here. She's the one that said to Melissa, oh, yeah, he was really nasty. He wasn't friendly. Look at the interchange between Ashley and Preston. Watch this. She's laughing. She's laughing at it. They're having a conversation. Watch, she's going to pump fist with the guy in the hat in a second. Preston's smiling. He's saying yes. Now watch Eve. She's going to lean in to try to get Preston's attention, and he's just not interested. Maybe that's why she said these bad things about him. Maybe that's why she said these. Very good. There you go. All right. There's a really guy that's really in a bad mood. Now there's a guy that has in his mind he's going to go outside and he's going to kill somebody. Look, so you're leaning in. She's trying to get his attention. He's not interested. Okay, thanks. Anyway, I suggest to you that there's absolutely no basis to put any stock in anything that these two people said, and certainly not conclude that Preston was dark and he was in a bad mood and he decided because of that he was going to go out in the parking lot and kill Garrett. It's dress up. It's what prosecutors do to add substance to a case and make some kind of an argument that he was in a bad mood when they are woefully short on the real evidence in the case. Let me take a minute to discuss with you the statements that Preston made. The state played Preston's interview, and then they belittle it, okay? But they're the ones that put it in. They played it. Fact of the matter is, Preston is the owner of this property, okay? They lease the property to the bar. He doesn't run the bar, but he owns the property. He has a responsibility to protect the integrity of this property. There's no question about that. And see that it's used in accordance with the licensing that's given by the state. Everybody knows that. It's no big deal. There's a tavern on the parking, and there's a parking lot in the back. It is an integral part of the establishment. Now, Preston discussed that in his statement, and he indicated that he had a relationship with Sergeant Duvalley. Why did he have a relationship? Sergeant Duvalley said that they had worked together in the past. You saw him say that on the statement, and you saw him say it on the witness stand. Why? Because there were drug dealers that were going in the parking lot during periods of time, and Preston would contact the police and say, please help us get the drug dealers out of the parking lot, right? That's what a good citizen does. That's what a good property owner does. So he said, that's why he went outside in the first place. He heard that there was commotion at the door, there was a lot of activity at the door, so he just went outside to see what was going on. But when he gave a statement to the police, he waived his rights, and he gave the statement to the police, or gave the statement to Detective Duvalley. I suggest to you that as the owner of that property, and based on the history of that property, what had happened before, and just trying to be a good citizen and protecting the integrity of the business and the use of the parking lot, he was completely reasonable and justified to pursue and confront Garrett for peeing in the parking lot. Think about it. It's a business. It's a place where couples come to go have a drink, maybe have something to eat. You're gonna take your spouse and you're gonna park the car, you're gonna get out of the car, and there's some kid with his pants down peeing in the parking lot. It's a reasonable thing, justified. It's a justified and a reasonable act for Preston to go to Garrett and say, hey, stop this, please, this is not what you do in our parking lot. What did he say? There's 3 bathrooms on the inside, go inside if you need to go to the bathroom. But that wasn't gonna work. And we'll talk a little more about that in a minute. Look, on the night of the incident, I suggest to you that there are at least 3 telltale events that will tell you that there is no basis to believe that Preston either acted with the intention to kill somebody, that he acted with premeditation, or that he acted with a depraved mind. What? 1. And you saw this before. Immediately after the shooting, what did you have? And the prosecutor pointed this out because she said that he didn't put the gun down quick enough when he was talking to the police. After it happens, you hear on the 911 call, Carson screaming at Preston, put the gun down, put the gun down, put the gun down. What does that tell you? It tells you that immediately after the shooting, the first thing that Preston wanted to do was get help for Garrett. The first thing he did was pick up that telephone, you can see it on the video, pick up that telephone and call 911 and say, I shot somebody, send the police and send EMS. This is what Preston did. Premeditated, he intended to kill him, but he's taking 911 call and telling him, please send EMS. He has a depraved mind. But please send EMS. And this is the first thing he thinks of, is making the telephone call to get him help. And this is Carson screaming at him to put the gun down. Put the gun down, put the gun down. Now remember, this, the government says, it's a premeditated homicide, a murder. He went out there intended to kill Garrett. Or he's got a depraved mind and he killed him because his mind is all depraved. Carson tells him, put the gun down. What does he do? He puts the gun down. Puts it on top of the car. Just puts it down. Waiting for the police, waiting for EMS to come. Premeditated? Depraved mind? I don't think so. Then, but what else happens in that interim is as soon as the shooting took place, okay, and they're down on the ground, and it's unclear who was on top of who, whether Garrett was on top of him or he was on top of Garrett. Carson runs in, and he grabs, you can see it in the video, he grabs Preston and he throws him against the wall, against the car. And at that point, Preston gets up, and he still has the gun in his hand. And somehow the gun, according to Carson, got pointed at Carson. Whether it was intentional or it was just a reaction of standing up, it makes no difference. But here's what happens. Carson puts his hands up, Remember, it's a premeditated shooting. they're alleging that Preston killed Garrett because he was peeing on the wall. This is his brother. He attacks him immediately after it happens. He's a witness. And then shoot Carson. Carson didn't get shot. Carson then turns his back and walks away. He doesn't get shot. Preston doesn't do anything. Preston was as shocked as everybody about what happened. So, let me just discuss with you for a minute why I suggest to you that Preston never intended to shoot anybody. What he did, and you'll hear it in the statements that he made, because you'll listen to the videos. He said, I went out there and I told him, I own this property. I own this property. And I'm armed. Okay? He says it several times during the course of the video with the police. And when Preston turns around for the second time and he walks over, he shows the gun. He shows the gun. He puts his hand on the gun and shows the gun. He doesn't pull the gun, okay? That's not deadly force. He puts his hand on the gun, doesn't point the gun, doesn't take the gun out of the holster. It remains there, but he shows it. And let me suggest to you what he was trying to communicate and what he said to the police, although indirectly. What he was doing was the same thing that, for example, in America, why do you think police officers in the United States wear uniforms? They wear these bright blue uniforms, they wear badges, gold badges or silver badges, and they wear guns that are fully exposed. Do you know what that is? That's a deterrent. That's I have authority and I'm armed, don't do something stupid. And I suggest to you that you listen to the tone and what he was trying to explain to Detective Duvalli. That's exactly what he was doing, okay? And that's why he was telling it. If you want to talk premeditation and depraved mind, he would have hid the gun. I'm going to kill him, but I'm not going to show him my gun. I don't want him to know that I have a gun. Why is he telling him, I own the place and I have a gun? I own the place and I'm armed. It was a deterrent. But it didn't work. You know why it didn't work? And by the way, you know, a police officer in that situation, if he finds that he's threatened after he declares, you know, he wears a uniform, he's a police officer, he has authority, he's on the gun, if his life is threatened or he fears that he's being attacked, he draws the weapon. But we'll talk more about how the weapon got drawn later. But there's an analogy that follows through that. But the reason it didn't work was because Garrett was just too cocky, too entitled, and too drunk to take the warning. That's what happened here, okay? His blood alcohol level was 3 times the legal limit. You'll see the video in a minute, he could barely walk across the parking lot to go to the corner where he was peeing. He was so drunk and he felt so entitled, okay? We would pee on that wall 1,000 times. We can do this anytime we want. What are you talking about? Who are you? Who the F are you? That's the attitude. That was the problem here. Okay? It's not, okay? That young man was killed and died as a result of that confrontation, not because Preston intended to kill him or that he suffered from a depraved mind. It occurred because he wouldn't take the warning and he decided he would reach for that bottle under those circumstances. Now, look. Don't misunderstand what I'm saying. I suggest to you that while the state says this is all Preston's fault, that's not true. Absolutely is not true. Preston bears all the responsibility for the death of this young man. Not true. Certainly this young man didn't deserve to die, okay? I'm not saying that, you know, he was arrogant and cocky and so drunk that he deserved to get shot. That's not what I'm saying. I don't think that's the case. But by the same token, Preston doesn't deserve to be convicted of these offenses, of these crimes, as a result of what happened. Sometimes things just happen. And you know, a human phenomenon that, well, somebody has to pay. It's gotta be somebody's fault. We're gonna punish somebody. Not always that way. What did, on one side of the mouth, they say, oh, don't listen to the earlier things that any of the other witnesses said because they were traumatized and it was a bad experience and it was right after the event. On the other hand, they're saying that, Preston, didn't say this, didn't say that, didn't say this, didn't say that, therefore you should impute all these terrible things, rather than the fact that he's given a statement to the police just a few hours after this incident happens, and they tell him that he shot somebody, right? So, we gotta look at actually what he said. What did he say? And Duvalli was here, and they played the video. He said several times, I'm giving you the overall scope, not the details, okay? He said several times, to the best of my recollection, this is what happened. He looks up at the ceiling several times, trying to answer the questions to the best of his ability. Remember, he didn't assert any of his constitutional rights, okay? He never said, I want my lawyer here before I talk to you, or I don't want to talk to you. He actually asked to talk to Duvalli, and he tried his very best to answer all the questions. Even the sergeant, even when I asked Duvalli, he wasn't surprised and said that it was not unusual for someone in that place, in the situation that Preston was in, to be confused and not really clear about what had happened or what he was doing. He said that Garrett had a shirt on. Let's just think about that, right? Garrett had a shirt on. Well, Garrett didn't have a shirt on. Everybody knows, that Garrett didn't have a shirt on. But Preston thought he had a shirt on. What does it tell you? And Sergeant Duvalli said, I don't think he was really lying to me about the shirt. That was what his perception was. He just wasn't recalling that clear, and his perception wasn't that clear. He welcomes a grand jury investigation. And you also find out that he says the same thing that Ashley Whalen said. He had 3 beers over 5 hours at the time. I can't explain the reading, the 1-1. I can't explain it. The prosecutor has suggested to you that it means that he must have been way, way drunk. I suggest to you, I don't see how drunk he could get on 3 beers, okay? He said 3 beers, and the barmaid, Wesley Allen, said 3 beers. So I don't know what to say. Now, this bottle. We'll get more to the bottom when we see the video. Preston did not actually see the bottle, or at least that's his perception. He says he didn't see the bottle, didn't actually see the bottle. But he said he was reaching for something, and that he felt that it was dangerous, that it was a weapon. This is what he felt. This is what he perceived. And he was right. Because in spite of what they said on their opening, in spite of what anybody else might say, you'll see there's no question that when he went over there, he had that bottle with him. It was an empty bottle. He put it on the roof of the car to his left, and you'll see on the video in just a couple of minutes how when Preston confronted him before the weapon was drawn, he turned and reached for the bottle, which caused Preston to draw the gun. And it's exactly as he stated. Did he see the bottle? Preston was lying, he was making up excuses. Yeah, I saw him pick up this bottle and he was going to beat me to death with it. Although it wouldn't surprise me if that's not what Garrett would have said. You see this bottle, I'm going to beat you to death with this bottle. It wouldn't surprise me based on the conduct that he portrayed earlier in the evening. But this is what Preston said. This is what he perceived. What were the circumstances? He actually perceived that there was danger, and that did he actually have to see the bottle to have reasonable fear? Did he? Consider the circumstances. He's faced with 4 young guys, 3 of them are behind him yelling, okay? He's faced with the 4th guy who is half his age and twice his size, peeing on the wall, not cooperating in any way whatsoever. We'll get a little more to that when we talk about Cheeto was just being Cheeto, okay? Everybody, all the witnesses will tell you this, okay? He wasn't cooperating. It was like, who the F are you? Who are you telling me? I can pee on your wall. I can pee on your wall anytime I want. I've done it 1,000 times. I can do this. Really? That was the attitude. So, they're in the thick of it now, okay? It's obvious that they're exchanging words, okay, and things are not going well. And Garrett turns and reaches for the bottle. And, it's interesting because you'll see in the video, when he was telling Duvale about this incident, that he told him that he was armed, he told him that it was his property, and he was confronting with this, and he saw him reach for the bottle, that Preston knew that there were four of them. And, because he said, if this turned out to be a fist fight, it would turn out a lot different. Okay, so he had real fear, okay? He knew that there were four of them. He knew that, and you saw from the scans, they weren't that far behind him. They were just a few feet behind him. And you've got Carson, who's saying that he's chasing after him, okay? When he sees him go over there, he starts following behind him. He's getting closer and closer and closer. And you've got Logan and Blake yelling, okay? Yelling at Garrett, but they're still causing a commotion, and Preston's out there alone. So, did Preston not actually see the bottle? Which was it? Did he not actually see the bottle, or was he just not able to articulate seeing the bottle? He saw something, and he knew that it was dangerous and it was threatening. It's a conglomeration of all the circumstances. I suggest to you that what Preston experienced was a human phenomenon. It's not unusual. Did you ever drive your car down the road and you're in a lane and you're going to change lanes? You're going to move to the lane on the left. You look in your mirror, you don't see anything, but you do this, and you sense there's something there. You don't know why, but you look and you know that there's something there, and it's dangerous for you to move that car into the next lane. And you don't do it, and 10 seconds later, a motorcycle goes by. Human beings are blessed with senses other than simple sight. And that's how we govern our lives. That's how we live our lives on this silly little round planet. It's not just actually what you see, and sometimes you see things and you're not sure that's what you saw, okay? And I suggest to you that it really doesn't matter whether he actually laid eyes on that bottle or he sensed the dangerousness of the situation and he reacted in accordance with that. It's the same thing, and it's a human phenomenon. And it's the same thing, what you know is that he was right, okay? I didn't see a bottle, but there was a bottle. We know there was a bottle, and we know he reached for the bottle. The same thing happens in the statement where he says, I fired the weapon. He said that several times. No doubt I fired a weapon when they were doing the GSR test. No doubt I fired the weapon. Of course he's going to say that. It was his gun. It was in his hand. It went off. Does that mean he consciously fired the gun? No. I'll suggest to you there's many different ways this gun went off, and only one of them, which I suggest there is no evidence that happened, is that he consciously pulled the trigger, and consciously pulled the trigger with the intent to kill this kid. That's what first-degree murder is. Or that he shot Garrett with a depraved mind, out of spite. That's not what happened. And the fact of the matter that he said, I fired the weapon, isn't determinative of the issue. That's what you need to evaluate based on all the facts of what happened. And you always have to keep in mind, by the way, that he's on his own property, by the way, okay? He's on his own property. He's not out someplace. This is his property. He has a right to protect. So, let me just show you just two real short clips of that interview. We have number two. Just watch it. This is a man that just, with premeditation, killed somebody. He's talking to DuValle that night. Go ahead.
Don't back, but who the fuck are you? We're just going back and forth on this thing, and it just, that fast. It was not a long, drawn-out process. It really wasn't. Because if it had been, then his buddies that were here would have, had they all come in together and had been a fist fight, things might have been different. But that dude was agitated already. I mean, you can test me for drugs or whatever, I don't know. I swear I hope he's okay.
I swear, I hope he's okay. I intended to kill him. My mind is all depraved, but God, I swear he's okay. Play the next one, please.
Can I ask you how
Can you
this
stop it for a
all
second? Can you stop it for a second?
Right now, he's,
The state played this on their closing, but they stopped it. Play the rest of it.
critical.
Start from the beginning. Want to hear it again? Yeah, please.
Can I ask you how the fellow's doing?
Right now, he's, critical.
Can I ask you how the fellow's doing? Critical. Fuck. Is that consistent with an intention to kill somebody? I suggest it's not. So, all right, let me talk about a couple other things. DNA, GSR. This is really interesting, okay? Even if you have even a remote thought, okay, to return a guilty verdict, this is the kind of evidence that I suggest will stick in your craw, like a fishbone, right? This is the kind of thing that will really let you know what's going on here, okay? There's no doubt that Garrett's DNA is on that gun. It's on the slide of the gun, all right? You know, how did it get there? How did he get there if he didn't put his hand on it, okay? Oh, well, he might have hit his stomach, he might have done this, he might have done that. The testimony is clear. Carson said he tried to knock the gun away, but on a prior statement, when he talked to the police, he said he tried to grab the gun, okay? He tried to grab the gun and get him in a chokehold, okay? Get behind him and get him in a chokehold. This is what Carson described that he saw when they were struggling for the gun, right? His DNA is on the breech of the gun, okay, the slide of the gun. And why is that important? Because while they're tussling for the gun, if his hand is on the slide of the gun, first of all, the magazine is on the ground. How did the magazine get on the ground? How did the magazine get out on the ground? You saw Detective Duvalli testify. The magazine gets dropped out of the gun if somebody either intentionally or accidentally hits the button on the side of the gun. If it's entirely accidental and you hit the button on the side of the gun, the magazine's going to fall on the ground. That's where the magazine was. It was on the ground. How did it get there? Somebody accidentally knocked that magazine out of the gun. How did the broken bottle? What about the bottle? How did the bottle? I suggest to you the bottle landed up where it wasn't. It rolled. Okay, that's why it was down in the middle. But he had the bottle. Garrett had that bottle right where they were fighting, and that's where the pieces of the bottle were found. How did that happen? There was a struggle. Okay, and Garrett had his hand on the breech of that gun. Now, why is that important? Okay. They tested Preston for gunshot residue. It was negative. Why did he press? Because he had his hand on the grip of the gun. They say, well, you know, it wasn't a good test. This is what the government does, okay? If it was positive, they tell you it's a really good test and it really works. If it doesn't work, they'll say, well, it doesn't mean anything because it doesn't work, okay? But the fact of the matter is the detective did the test. This is what the test was. This is what the result of the test was. There's no evidence that there was GSR on Preston's hands. Now, are we trying to say that no, he didn't have the gun? Yeah, he had the gun. Where did GSR go? Where does the GSR come from? It comes out of the barrel of the gun, which was buried in Garrett's abdomen, which, by the way, according to the ME, could either have gotten there either through pulling it or pushing it. One way it got in there during the course of the struggle. And what happened to the GSR? If Garrett had his hands over the breech of that gun, where his DNA was, I suggested you we would have blocked the GSR from coming out And that's why Preston didn't have GSR on his hands, because Garrett had his hand over the breech of the gun when the gun went off. But you would think we would know that. What happened? They bagged Garrett's hands to protect the evidence. He went to the medical examiner. The medical examiner unbagged his hands, swabbed his hands for GSR and other things, gave him to the detective, and that was the end of it. Gee whiz. Do you think the government had an obligation to find out what the situation was? They never tested it. We don't even know where it is. It's gone. Anyway, what did we learn about Garrett from the testimony? Okay, we know a couple of things. We know that Blake and Logan and Carson all testified earlier. They all went to depositions, okay? When they went to depositions, the Hughes family hired lawyers for them, for Blake and Logan. Why? What do you think that was about? Why would they send them, give them lawyers before they go and testify about what happened? Think it was to be sure they told the truth? Or was there some other motivation? But they did. And so they started on this journey of telling this story, and they still told several different things, but we learned a couple of things. One, Garrett was wildly drunk, okay? He was 3 times the legal limit. It was a 2.4. When Logan and Blake first saw the encounter begin, when Preston starts coming out of the building and he starts walking over there, yeah, he's got his hand on his gun, they start yelling. Blake and Logan and Carson start yelling. Are they yelling at Preston? No. They're yelling at Garrett. Why are they yelling at Garrett? Yelling at Garrett. No, no, Garrett, it's Cheeto, no, no. Logan. Cheeto, quote, his words, shut the fuck up, close quote. Blake. Cheeto was just being Cheeto. You know, quote, fuck you. Close quote. This is what we've learned about Garrett. This is before we even look at the video. Blake talked about Garrett being an athlete and the kind of kid he was, you know, and he said, oh, he's not aggressive, but he's not going to let somebody take advantage of him. He's not going to let anybody walk on him. What does that tell you? Cheeto just being Cheeto. Now, you know, Melissa and, you know, I don't have any idea what Melissa, but Blake said that at one point he saw Preston raise the gun and try to hit Garrett with the gun, with the side of the gun, pistol whipping. I think this was happened at the very end of the encounter, and I think that Melissa said the same thing, although I don't put any stock in anything she said or where she obtained that information. But I suggest to you that raising the gun and trying to hit somebody with the side of the gun is not using the business end of the gun and evidence and intent not to shoot the gun, okay? If you have a gun and if you're threatened by some other weapon and you elect not to shoot somebody, it's not unreasonable to use the side of the gun to hit them, to defend yourself, which is wholly inconsistent with a premeditated murder. So, Blake saw that they were entangled, and as you know from the testimony, as I said before, Garrett is what, 6 feet, 176 pounds, and according to Detective Duvalle, Preston is 5 feet 7 inches, 130 to 140 pounds, half his age. Why are they yelling at Garrett? What is that all about? Cheetah, just being cheetah, quote, fuck you. What is that? I suggest to you that says a lot. That really tells you more than just saying, shut up, okay? They knew that he was talking trash. There's no doubt about it. That's why Logan said that. But why did they say Cheetah was just being Cheetah? It's not just what he was doing that particular time. Cheetah was just being Cheetah. It indicates that they knew his character. They knew how he was going to act. They knew from, I don't know what their experience was, but Cheetah was just being Cheeto, F you. And that scared them. They were terrified of that. Why? Because they knew he was going to escalate this. He wasn't going to let it go. They knew that he wasn't going to let anybody walk on him. He wasn't going to let anybody take advantage of him. And his mindset His entitlement was that I can pee in your parking lot any damn well time I please. That was Carson's attitude. Of course, we pee in that parking lot all the time. Why not? We could do this. And, you know, why not? That was the attitude, and that's what caused this incident. And, you know, their fear was justified. They were right, because that's exactly what did happen. Garrett escalated this entire incident when it didn't have to be. Because what happened? Garrett tried to knock the gun away, okay? At one point, the gun was drawn, and we'll see in the video when the gun was drawn. The gun was not drawn until he reached for the bottle. The gun was in the holster until he reached for the bottle, and he reasonably frightened Preston that he was going for a weapon, and he was going for a weapon, and that was the bottle. They wrestled for the gun. They went down to the ground, and you'll see that this gun did not go off until they were practically on the ground. And then the gun went off. It was a contact wound. Ask yourself this. Preston walks up, according to the prosecutor. He pulls a gun. And with premeditation, with the intent to kill this person. He doesn't shoot the gun. If he was going to shoot him, why didn't he shoot him when he was 10 feet away? Why didn't he shoot him when he was 5 feet away? Why is he going to get tangled up with a guy that's half his age and twice his size when he's got the gun and it's his intention to kill him and shoot him? How does this happen? How is this consistent with that mental state? It's not. They knew that Garrett was an incendiary personality, and this is where it was going to go. That's why they were so terrified. That's why Carson was chasing after him. That's why they said Cheetah was just being Cheetah, F you. And Logan is yelling, shut the F up. Shut the F up. Cheeto, shut the F up. Why is he doing that? Why aren't they yelling at Preston? They're yelling at Cheeto. They knew he was the dangerous element in this incident. And look, you get a real insight when Carson took the stand. On more than one occasion. He didn't like the questions that I was asking him. He drops the F-bomb. He has absolutely no respect for this institution to come in here and say, F this or F that. No, I didn't F and get shot. I asked him about the encounter with Preston after the shooting, and he didn't get shot. I wanted him to say that. He didn't get shot. That even though right after they alleged that Preston shot Garrett, that, you know, Carson attacks him and he doesn't get shot. No, I didn't effing get shot. What is that all about? Then I give him a transcript. I give him a transcript to look at. I don't know if you saw this. When he's done with the transcript, I give him a transcript, he throws it on the floor. He threw it on the ground. He just threw it on the floor. Okay, I picked it up. This is an attitude of entitlement. This is why they knew that Garrett was going to start a fight, okay? That Preston's behavior on the witness stand was just the same kind of attitude you were getting from Carson. And he knew, and that's why he was so frightened about what Carson was going to do. He knew what was going to happen. He knew that Carson was going to accelerate this. That's why he's got this tattoo. I am my brother's keeper. That's why. You know, there's this whole verbiage, the choice of the words that were used by the prosecutor throughout the entire incident. Who was the aggressor? Who was the aggressor? Who was the aggressor? Who was the aggressor? And you get somebody like Melissa or all the other witnesses who put the words in the mouth. Preston was the aggressor. Preston was the aggressor. Let me tell you this. Preston owned that property. He was responsible for that property. He was responsible for people that were leasing the business to. He had a right, if not an obligation, to pursue and confront Garrett for peeing in that parking lot. So when he starts out here and comes out that door and he sees what he's doing and he starts jawing with him and he goes over there, he has every right to do that, if not an obligation to do that. So they characterize it as being the aggressor. I characterize it as asserting his rights. That was his property. He had a right to do that. put his hand on his gun, I suggest to you, as a deterrent. Just like he told the police. I told him that I own this property and I'm armed. Don't be stupid. But as I said, Garrett didn't take the warning. He was too entitled, and he was probably too drunk. So what did he do? We're gonna look for a minute now, what he did. Can we have these, the two videos, can we have them forward? What we're gonna do now is I'm gonna show you, there are two videos that were enhanced. They're in evidence, and they will, I suggest to you, clear up some questions. Can you just, just please start it, but don't, just turn it up. Okay, all right, this is one view, okay? That's Melissa going out to her car. And she gets in her car. In a minute, you're going to see Garrett come out. You know, these two guys getting in this car are not part of this. They're just getting in their car and they're leaving. I think there's two of them. What you're looking at is a video of the actual event, not a reenactment, not a pictures that were taken later. What you're going to see is exactly what happened that night. Stop it when I tell you, okay? Not yet. Keep going. Play it? Keep going, yes, please. Okay, there's Garrett. Watch him. No shirt. Beer bottle in his hand. They're gonna finish off that beer. Watch him. Now watch him, he barely can walk, he's so drunk. Look at him. That's how drunk he is. Now he's yelling back at somebody, I think he's yelling back at Carson. We don't know what he's saying, but this is what he's doing. Now he's gonna walk over, look at him. Totally drunk. Now watch what he does right here. Right there. Puts the beer bottle on the roof of the car and goes to the wall to pee. I suggest to you, there's absolutely no doubt. Carson even said that he saw him take the beer bottle and put it on the roof of the car. Now the bottle's on the roof of that car, to his right, as he faces away from the wall. But right now, it's to his left and on the roof of that car, and it's right there. Now watch what happens. There's Preston. Yo, what are you doing? Why don't you go inside and pee? We got 3 bathrooms in there. Now he turns around. What do you think's going on here? Okay? They're jawing at him. You can see it. They're jawing at Preston. He turns around. What's going on? Hey, you know what? He's peeing against the wall. We all pee against the wall. He puts his hand on the gun. Okay? This is not deadly force. I suggest you, can you stop for a second? Puts his hands on the gun to send that message, that deterrent, don't do something stupid. Why? Because you know from the testimony that between the two of them right now, there's a lot of bad words. There's a lot of talk that's going on, a lot of, as was described, trash talk, okay? This is what's going on. Almost everybody that was there said they heard it. At the same time, you've got behind him Carson bearing down on him, and you've got Blake and Logan also behind him yelling at Cheeto. Can you start, please? Okay, watch now. Okay, stop. All right, now they're facing each other, and you can see the gun is in the holster, and Garrett is just starting to turn. Where's he turning? Why is he turning? Watch. Good. Gun is still in the holster. Still in the holster. Now he turns and he comes towards, okay, Preston, and they meet, and they get into a tussle. Watch. Now, stop. You go over this again in the jury room, but you will see exactly when that gun went off, okay? Melissa testified that she heard the gunshot. She didn't see the shot, she heard the gunshot, and she jumped. You will see, and you should look at it again, that when she jumps, they're already down almost behind that truck because they're struggling and they're heading for the ground. How did the gun go off? Can they prove to you beyond a reasonable doubt with depravity, okay, or with intent that Preston was the one that pulled the trigger on that gun and shot it, or did it go off as a result of the struggle? With DNA from Garrett on the gun. And it being a contact wound, okay, where the barrel of the gun was right up against his stomach. How did that happen? Can we see the next one, please? We're going to show you one from the other view. Same incident from another view. Yes, please. That's okay. Well, you can, just for a second, you can see in there that the struggle, over here, you can see the struggle that's taken place between Garrett and Preston. That's what we described when Carson, excuse me, between Carson and Preston. This is Garrett here. Between Carson and Preston, when Carson ran up there and attacked Preston, and the gun was pointed at Carson, but he didn't get shot. Okay. Can we try the next one, please? This is another video. This is exactly same night, same thing, only from a different perspective. This is from the other side of the parking lot. In just a few seconds, you're going to see Garrett come out. He's going to be just as drunk as he was when you saw him in the last one. This is an enhanced video, you know, that we'll show you. Okay. There's Garrett. Hold on. No, that's not Garrett. Here, hang on. There he is. That's Garrett right there. There he is. You can see him emptying that bottle of beer. No shirt. Okay. Now he's going to stumble over, and you watch. You'll see here. He goes, and you'll see, even in this picture, you can see, he goes to that car, puts the bottle on the roof of the car. Watch him. There. See? There he is now. And now you'll see him lean, puts the bottle on, and now you'll see him move and go to the wall to pee. There's no question, based on the video and even the testimony of Carson, the bottle's on the roof of that car. That's why you saw pieces of the bottle here and the broken bottle down here after. Now he's peeing on the wall, like he has a right to do. Okay. There's Preston. Okay. Hey, what are you doing? Stop peeing on the wall. Okay. He's got Blake and Logan behind him. Carson is over here someplace on the other side of the Jeep. Turns around. Now he comes back. Okay. Now he's walking back. Can you stop it for a second, please? Okay. There he is. The gun is in the holster. Okay. Now watch Garrett. Continue. Watch. Stop. Please stop. Now. There's Garrett. Garrett turns and faces Preston, okay? This is when Preston is saying, I own this property, I'm armed, stop. okay? The message, don't do something stupid, just get out of here. Watch what happens. You're gonna see now, watch. What? Boom, watch, stop. There he is. He turns for the bottle. He turns, the gun is still in the holster. Watch, go ahead now. Turns for the bottle. Now the gun comes out. The gun doesn't come out of the holster until he turns and grabs the bottle, and there's the bottle, okay? And then they get into a tussle. Why did they get into a tussle? Now they go down to the ground, and that's when the gun goes off. Did Preston try to hit him with the gun? I don't know. Some witnesses say he tried to hit him with the gun. Can you stop it? Some witnesses say he tried to hit him with the gun. He didn't shoot him. Why didn't he shoot him when he was standing back here? Well, as soon as he turned for the bottle, he was, what, 7 or 8 feet away? If he had depravity in his mind, if he had intent in his mind to shoot him, why didn't he shoot him then? Why does he get in a struggle with a guy that's twice his size, half his age, and wind up on the ground when he's got a gun, and as the government says, he's intending to kill him? It doesn't make any sense. Okay, thanks. Anyway, so, look, as I've said before, some things happen, and some things, they just happen. And as I said, it's a human phenomenon to try to blame somebody, and in this situation, it's just not right to charge Preston with these crimes. This is pretty much an all-or-nothing situation, okay? If you can't find that he, A, acted with premeditation, or B, that he acted with depravity of mind, okay? Imminently dangerous conduct and with demonstrating a depraved mind which is done for ill will, hatred, spite, or an evil intent. If you can't find either of these things, the verdict must be not guilty. The verdict must be not guilty unless you can find either one of those things beyond a reasonable doubt. If you find that he did it intentionally, then you can find guilty on murder 1. If you find that he had a depraved mind, you can find guilty on murder 2. Only if you find beyond a reasonable doubt that those elements exist. Okay, well, I have good news and bad news. What do you want first? I'll give you the good news first. The good news is I'm just about done. The bad news is they get to go again. But that's okay. Those are the rules. This is what it is. They have this time, and they have a chance to respond to what I've said. As I said, I think in my opening, this is the two-step process. You individually decide how you feel about these charges, whether you should find him guilty or not guilty on either of these charges. And then you must deliberate and work toward trying to have an agreement, if you can. If you can come to an agreement, all 12 of you agree, have the same decision as to guilt or not guilt. And obviously the verdict must be unanimous. Inasmuch as I don't have a chance to respond to what they're going to say, I'm going to ask you if you would, while you're in the jury room, respond as if I would respond. Somebody respond for me. If they say something and I don't get a chance to respond to it, during the course of the deliberations, think about what I might say in response to what they're going to argue, and somebody respond on our behalf. Thank you very much.
Thank you. State now has an opportunity to make their final closing.
Just me, just put it in here.
All right, we've done an opportunity to set up. If anybody wants to take a quick stretch, break, stand up, because we're going to hear this argument, and then we're going to take a break before I give you closing instructions. So, in a moment, everybody wants to stand up and stretch as I'm doing, be my guest. If not, that's fine too.
21-year-old Garrett Hughes, his life was taken from him, his family and his friends, over a juvenile, trivial act of urinating on a building. Garrett Hughes, also known as Cheeto, lost his life due to a grossly disproportionate, deadly response to a minor act that was completely unjustified. Shirtless, flip-flop wearing, intoxicated Garrett Hughes was held at gunpoint by that man, who was irritated, annoyed, rude, and upset because Garrett Hughes peed on a wall of a building instead of using the bathroom. And when that man started yelling at Garrett Hughes, and Garrett Hughes started yelling back, it wasn't enough. Despite the fact that Garrett had finished urinating, had finished going to the bathroom on the wall, the defendant continued on. And he continued intentionally, deliberately, and purposefully to attack Garrett Hughes, which went from mere words to that man grabbing his gun, drawing the gun, taking what we called a bladed stance, and aiming it at Garrett Hughes. And ladies and gentlemen, the one thing that the defense doesn't talk about is that this did not happen immediately. When he pointed the gun at Garrett Hughes, there is 9 seconds that lapse from the time he's pointing the gun at Garrett to the time you see Melissa, you see Logan, you see Blake react. I suggest you go back and watch that video. You watch the little counter on the top, the surveillance camera that the defendant had, and you count from the time you see that gun pointed at Garrett Hughes. 9 seconds. You want to talk about premeditation? You want to talk about the intent? You want to talk about consciously deciding and have a reflection? 9 seconds. And the instruction says there's no time period. We don't have to say it happened for 9 seconds. We have to prove that it was present. And this, ladies and gentlemen, is so much more than a depraved mind. This is so much more than ill will, hate, and spite. Because he made a series of acts consciously, deliberately, when he pulled that gun out and charged Garrett Hughes and fired that weapon. And that's exactly what the evidence has been, that the evidence has shown you and proven beyond a reasonable doubt over the last 3 days. And that's exactly the crime of first-degree murder, and it was absolutely not justified. Now, I'm not going to take you through as much as we went through over the course of the day, over the last few days, but I am going to highlight a few things that I believe proves these elements beyond a reasonable doubt. I think we heard in the beginning of the defense's opening that it's all about the timing, that timing is everything, and I agree. Timing is everything in this case. Let's look at Garrett's actions and movements versus the defendant. Who traps who? Who traps who? The defendant traps Garrett. When is the gun aimed at Garrett? The defense makes this big deal like, oh, it's at the time he turns his back. Sure, maybe it is at the time he turns his back. But again, you're going to see that Garrett turns around. There's a time that he's facing the defendant and he's still pointing that gun. Who is displaying the deadly force? Mr. Mansfield indicated that a bottle, and used my bottle, a bottle in and of itself is not a deadly weapon. I'm going to get to this a little bit later, but there's no evidence that this was in Garrett's hand or being used or displayed as a deadly weapon. None. Who attempted to leave the 12-foot space he was trapped in? You saw the measurements. It's 12 feet between those two cars. Garrett was trapped. He was cornered. Who tried to leave the area? Garrett did. Who advances on whom? Watch the video. Who is cornered? Watch the video. Listen to the testimony. Who had the right to defend himself? Mr. Mansfield went over the instructions, and it talked about who has the right to use deadly force. The state would submit to you the minute that Garrett Hughes had a gun pointed at his face, he had the absolute right to defend himself. He is the only one that night that had the right to defend himself. And also, who is the initial aggressor? We talked about that in opening. Mr. Mansfield talked to you about it when we talked about the self-defense instruction, and we'll get to that a little bit later. We also heard that the devil's in the details. Absolutely is, ladies and gentlemen. The devil is in the details. Let's talk about this infamous Bud Light bottle. Was it in his hands? Was it displayed in a violent manner? What evidence has been presented from that witness stand? Not what I say, not what Mr. Mansfield says, not what the defense says. What evidence? None. He wasn't flailing his hands. He wasn't acting in an aggressive manner. What evidence? You have Melissa, Logan, Blake, Carson all saying no, not in his hands, not being used in a violent manner. All of them say the same thing. And on the other side, you have speculation, pure speculation. But I want to take just a moment to address something that defense made a point of bringing up. First, I want to talk about Melissa Roberts. Ladies and gentlemen, she did not walk back anything. She did not walk back anything in her testimony. She was asked, was there anything in his hands at the time that gun was aimed and shot? No. What she said was that at the time Garrett walked across the way of the parking lot, yeah, he had a bear in his hand. You just saw the defense showed the video where Melissa's walking across the parking lot. She's in the car at the time Garrett's walking across drinking that beer. That's not an inconsistency. That's not walking something back. She said no. Let's talk about Carson, because the defense made a big point to talk about how Carson, who lost his brother, how he behaved on the stand. Think back as to the questions he was asked by the defense attorney. Think back as what he had to explain to you. Think back on how he was treated by the defense attorney. And think about what he said. And think about what he told you happened. Was Carson upset? Absolutely. Did he sit here and listen to his friends describe what they saw the day before? Yes. Did he get on the stand and have to tell you what he saw happen? Yes. The defense wants to talk about how people act. They want to talk about the witnesses, but they don't want to talk about their client, because he's the one on trial. He's the one that is absolutely guilty of this crime, and we've proven it beyond a reasonable doubt. And also, the state is not embracing this bottle. No, I didn't mention it in opening because it's a non-issue. I'm not hiding anything. I asked the detective about it. So again, the defense makes comments about what we're doing, but I'm going to ask you to think about, what does the evidence show? Because that's the only thing that matters in this case. Not what I say, and certainly not what the defense attorney says. So the other person who we talk about the bottle is the defendant. What does he say about the bottle? Nothing. Now we hear from the defense, oh, well, maybe he perceived it, I don't know. But, ladies and gentlemen, the bottle was sitting right here. The defendant was on scene for 90 minutes. He had a clear view of the bottle. Nothing. Again, the bottle is not even an issue in this case, because when you hear of the laws, you hear the instructions, It is not relevant. It is not an issue at all. Even if it was in his hand, what evidence is there that it was broken? None. I asked the detective, did you check the car? Were there any scrapes or any marks? No. Did anyone hear of the bottle breaking? No. Was anything being displayed in a violent manner? No. Timing is everything. Garrett Hughes, the defense just made a point and had you look at these videos over and over again and said, look how drunk he is. He's so intoxicated. All the more reason why it is so unreasonable for that man to be in fear of great bodily harm and death. He's so intoxicated. And when Garrett does turn, he does turn, and yes, the video does display that. When he turns around, what is he faced with? He's faced with this gun being pointed at him from approximately 18 feet away. This is just an estimate, but I'm 18 feet away from that bar. That's how far away he was from the defendant when he's taking that bladed stance from the Garrett and pointing it at him. But the defendant doesn't know what's in his hands. He goes to this, well, I saw him reaching for something. Well, we're going to get to that in a minute. But before we do, think back to the instruction. Who is the initial aggressor? Who? Bottle in hand or not. This is a loaded gun being pointed at a shirtless, intoxicated man. That, ladies and gentlemen, is aggression, and he's the initial aggressor. And even again, if you conclude he had this bottle in his hand, I submit to you, he had the absolute right to defend himself. He's being faced with deadly force. Now, let's talk a little bit about the reasonable belief, and we're talking about self-defense. Let's talk about how it applies, what the law is, and I'm going to first take with the initial aggressor because that's what we were just talking about. Again, who escalates it from a verbal confrontation? Who's trapping who? You can clearly see he trapped Garrett between the cars. Who displays a deadly force? And who did not withdraw? All of those are in the instructions. You get the packet, you follow it, you're going to see that the defendant is not entitled to self-defense for the first reason, because he's the initial aggressor. The second reason is he's committing a forcible felony. Ladies and gentlemen, if someone points a loaded gun at you, not just loaded gun, not just pointing the gun, if someone who is screaming and yelling at you, telling you, why the fuck are you urinating, why are you doing this, and pointing a gun at you, ladies and gentlemen, that is aggravated assault with a deadly weapon. So it's not just him pointing the gun, he's having words. He's clearly mad. That is a forcible felony. The second reason why he is not afforded the justification of shooting Garrett. And the last one is the reasonable belief of death or great bodily harm. Look at Garrett's appearance. Look at how steady he was on that video. What did the individuals that testified talk about his movement? He was staggering. He was unsteady. He looked confused. He wasn't charging. He wasn't steady on his feet. Those are things you have to look into when you're deciding whether or not that man had a reasonable belief that he was going to sustain death or great bodily harm. And it has to be an imminent threat. I go back to the 9 seconds. Even if the defendant believed that Garrett was reaching for something, there's a period of time that they're face to face. Garrett's hands are visible. What is the immediate threat? I'll submit to you the immediate threat was that man and what he did thereafter. So for those 3 reasons, he is not entitled to self-defense, and we have proven beyond a reasonable doubt this was not a justified use of deadly force. Now, in his interview, you heard the interview from when he was with Officer or Detective DeValley, but then also with Officer Lopez. This is my recollection. You have your own. On 6 separate times, he says he appeared to be reaching for something. And then he says something about his waist. Ladies and gentlemen, he had shorts on. Where in the world is the gun or the weapon going to be hidden that that man couldn't see? 6 times he says it. That's it. There's a face-to-face, I talked to you about this, in a passage of time, go back and watch it, count, 9 seconds. And this goes into the premeditation. This comes into the premeditation because he had time to reflect. He had time to be conscious. And there's 9 seconds that passes. And there's absolutely no overt movement by Garrett. Why is it first degree? Well, you have the eyewitnesses' testimony, the physical and digital evidence, versus the defendant's statements. They're in conflict. No doubt about it. And the defendant does not have to prove anything. He didn't have to speak. But the law allows us to introduce his statements, which we did. And that's evidence that you get to look at in determining whether or not, 1, was it justified, and 2, is it first degree or second degree murder. So let's just briefly listen to what the defendant had to say.
Right, you walked out of here, you were walking, you walked out of Conchtown, you walked in there when you engaged in
He
the,
was started pissed, and he said his pants up, and we had words, and he came at me.
okay.
And
Ladies and gentlemen, the defendant himself just admits he zipped his pants up and we had words. It was done. As Mr. Mansfield said, it was done. And go back to what the witnesses said. When Mr. Brewer works out the first time and does this, that's not when words are being exchanged. He turns around, sees the guys who he claims is somewhere else, doesn't know if they came from the bar, and then goes back, pulls the gun. That's when the words are happening. By his own admission, the act is done. Why are you going back there? As Mr. Mansfield said, he took the beef to him.
And, I mean, there's no reason for me to do it, guy. It's just pissing other than verbal. Just, really, come to the fucking bar. They got 3 bathrooms.
I got you.
So I don't know, beyond that, I didn't know him. He had no reason to have malice for me, but I'm aware.
Right.
I mean, a lot of people don't, you know that.
Yeah.
I did not recognize him as someone that I'd run into before.
Okay. Alright. And as far as words, you can't remember what told or anything like that?
No, it was all, I hate to say it, but when you hear battle and you hear the moment, words are exchanged, yes. Can I be verbally abusive? Yes. Okay. But did I walk up and strike him to cause him to come in? No.
Right, okay.
Look at my size. I mean, and my recollection is the guy was a little bit taller than me.
Alright. Did he hit you? Did he strike you?
No, he came at me in a threatening manner,
Okay.
and it appeared as though he was reaching for something.
Okay.
He was coming in to me.
Alright.
And
Did you see what he was, what he was
No.
reading? Alright. So, just so I get it right, you walked out of here, you were walking.
I walked,
Sorry, Lee.
and it appeared as though he was reaching for something.
Okay.
He was coming in to me.
Alright.
And
Did you see what he was, what he was reaching at or anything like that?
I did not.
Alright.
I was gonna have these words and yell at him and have issues. Because I mean, where he ended up, to the best of my recollection, was outside here, okay?
Behind the cars.
Right, outside now. And you tell me if I'm incorrect. But, yeah, so he obviously came toward me. Did you find him here, next to the building? No. You found him in the middle of the parking lot, which is where I was. Which means he came to me.
Ladies and gentlemen, is that consistent with the physical evidence? No. There's the diagram Mr. Brewer drew. He said, where did it all happen? Right here. That's not where it happened. Where did Mr. Brewer say his buddies were? Oh, on the side of the two cars. That's not where they were. They were over here. And the altercation, by way of the physical evidence, all happens here, ladies and gentlemen. So who had to charge who? Physical evidence, video evidence, witness testimony shows you what happened. Now, I'm going to move this just up because you've seen it so many times. And ladies and gentlemen, I will tell you that you have an opportunity when you go back and deliberate to watch these videos. We have a laptop, we have a monitor. I encourage you, don't take our word. Go back and watch it. Watch it as many times as you want. You'll get to see the physical evidence, the digital evidence. That is for you because you decide what we have proven beyond a reasonable doubt. Again, I tried to put them together so you can see both angles at the same time to show exactly the sequence of events.
I went out back, and it was not one, this was not a drug dealer, I don't think, just a guy. And he had buddies with him, and there were cars, but he was in between two cars, there were people on either side, and I guess they were all together.
Ladies and gentlemen, when Mr. Brewer is saying this, it is approximately 6 o'clock in the morning, 6 hours after the shooting. Remember, he's at .111 at 7 o'clock. Maybe that's why he can't remember where the gentlemen were and has them positioned in a different location.
Parking lot, on the building. And I said, man, can't you just go and I'll be honest, can't you just go in the fucking bar and piss in the toilet? And we exchanged words. And as it progressed, he became more agitated and approached me. And I said, look, I own this. Stop. He continued to approach. I said, I'm armed. It appeared as though he was reaching for something. The first shot went off this way. The second shot went off up in the air. To the best of my recollection, he was already on top of me. It happened that fast.
Okay.
There's no doubt I fired a weapon.
Okay.
Because they wouldn't let me wash my hands.
Yeah, what do that?
It happened.
Right.
I immediately, once he was down, did not continue to assault him, set my firearm on the hood of the car,
Okay.
awaiting the arrival of the police. I did not render aid because other people showed up to render aid.
Okay.
Immediately put the gun on the hood of the car. Is that consistent with the 911 call? No. He had to be told by Carson, put the fucking gun down. He's walking around with a gun in his hand, and the defense wants you to say, well, look, he dropped the magazine. He doesn't have an intent to kill anyone because he's still got the gun in his hand. Ladies and gentlemen, the premeditation, the conscious decision, the reflection comes for him shooting Garrett. The fact that the defendant is walking around and not pointing at anyone else or shooting at anyone else does not go to his intent or his state of mind when he charged, trapped, and killed Garrett Hughes. And the fact that the defendant shows some remorse after he's been at the station being told that the guy was shot and is critical, the fact that he says, oh man, or fuck, does not exonerate him from what he did. Do not confuse the defendant's mere words of, oh, I hope he's okay, to negate his conscious, deliberate act of killing Garrett Hughes. Just a few more, ladies and gentlemen.
At what point did you draw on him? Was it here?
When I fired, he was about this close. Because I fired on him appeared as though he was reaching for something, and he's coming at me. And by the time he got that close, I fired it. He's on top of me.
Did he fall on you?
He came down.
Or did he, like,
My second shot went in the air.
okay, so were
He was on,
you fell on the ground? You don't know if you fell on the ground and fell back?
yeah, he came at me. Yeah, because when I got up, but he wasn't on top of me. By the time it all ended, he was on the ground.
Okay. So I'm just trying to.
Do you remember where he was reaching? Like, was he reaching?
It looked like it on his side,
Okay.
which is where I carried a firearm.
Shirtless.
I mean, there was no reason for this.
On that point, we agree. Absolutely no reason for this, but here we are.
At what point did,
I don't know if you were holding the gun in one hand or with two hands.
Me,
Were you able to actually
when
watch
I,
out properly?
I don't know. I will tell you what the best of my recollection is.
I'm sure it happened pretty fast.
2, 1.
Don't know if you were holding the gun in one hand.
Ladies and gentlemen, the defendant claims it was 2-1, but that's not even consistent with the video. He had it out. It's not 2-1. It's pull out, 9 seconds, charge, cut Garrett off, fired, not once, but twice. Twice. Why is it premeditated? Let's talk about the distance, the direction, and the length of the defendant's travel. You saw this wonderful presentation from the Key West Police Department. We have this beautiful Faro scan. Yes, you heard it was very expensive, but it does a great job. Ladies and gentlemen, these are the measurements. So it is 33 feet from the corner of this Jeep to the corner of the car that Garrett was by. 33 feet. The defendant walked 33 feet holding the back of the gun. 33 feet. And trapping Garrett in a 12-foot diameter. 33 feet. Intention, premeditation, series of acts. You also were told that from the point in which we see him hold the gun, Garrett is 48 feet away. Why is someone holding the butt of a gun at that distance? Why? And then we have the last measurement that was taken, which is approximately 18 feet. And they used, from the video, they used where it was he was pulling, he drew his weapon. And ladies and gentlemen, you know when that happens because you see Logan stop in his tracks. That's when the gun is pointed. You see the motion. He is 18 feet away. But he then closes that gap, ladies and gentlemen. He charges against Garrett. So that is why it's not this 2-1, and it's premeditation. Why is it first degree and not second degree? At the time he holds the gun, walks 33 feet, pulls the gun, and then closes the gap on Garrett, that is why you can find there was a premeditated killing. It's not an accident. That's never been something that has been presented. It wasn't an accident. It wasn't a, oops, it happened. It wasn't a struggle, it went off. It was pressed up against his abdomen. He unequivocally stated he fired on him. Fired on him. And he fired a second time. It is more than a depraved mind. He trapped Garrett. When Garrett saw an opportunity to remove himself from that situation, which he had an absolute right to do, you can see it. Yes, They both walk in the opposite directions. Brewer walks this way, Garrett walks that way. And the minute that Garrett starts making his way to escape, that man charges at him and cuts him off. He had nowhere to go. Melissa Roberts said he didn't have a chance. That is why it is more than a depraved mind. That is how you can find reflection. That is how you can find he consciously decided to do so. And why we are here today, what brought us to this point, is all the defendant. This all started because the defendant, who was angry, pissed, agitated, who didn't get a female suitor he was looking for, you heard that in the interview, didn't have a good time with the bartender who didn't like his advances. He was pissed. And he was upset, and he was also intoxicated. And he made the decision to confront Cheeto. And because he didn't use the bathroom, because he was peeing on the wall. The defendant took it upon himself to drastically escalate a juvenile, nonviolent situation by physically confronting, trapping, and attacking and shooting Garrett Hughes. The evidence has proven he was not justified. He was not justified. And to use his own words, there was no reason for this. And on that point, and only that point, we agreed. And Garrett Hughes, AKA Cheeto, despite the efforts of his brother, his friends, and medical personnel, died February 13th, 2023, at the age of 21. And he died at the hand of that man's criminal act of first-degree murder. That's what it is. And I, who stand here on behalf of Dennis Ward, the elected state attorney, I am confident that when you go back and you look at the evidence, the testimony, you use the laws and the instructions that you will be given that will guide your decision, and you use the most important trait, your common sense, that you will agree and you will return a verdict of first-degree murder for the death of Garrett Hughes, and you will absolutely find it was not justified. Thank you.
Okay, members of the jury, we appreciate your patience and attention during the closing arguments this morning. So here's what we're going to do next. I'm going to give you a break till 12:05. During this break, I've asked Deputy Riccio here to pull out some lunch menus, because I don't believe it's wise to have you all disperse for lunch as we've usually done. So there is, in fact, a fund that is maintained at the clerk's office to provide a meal for jurors when the judge determines that they should all be kept together. And that's exactly what is appropriate at this particular point. So you're going to have a chance, again, this is not at your expense, it's from this fund, to order a noon meal. Then Deputy Riccio will take those, we'll call them in. Once the break's over, you'll come back and we'll give you the closing instructions, the law. Then you'll be able to retire to start your deliberations. The lunch should be about ready to be brought in at that time, so you'll be able to have your lunch, you'll be able to start your deliberations, and I think that's the best way to handle it. So take a break till 12:05, the usual rules apply, and then we'll come back for closings. All right? Okay, so the jurors are gone, so, I have just a few housekeeping details that I want to be, clear on. You mentioned the laptop. We talked about that yesterday at the end of the, charge conference. Is it here?
Yes, Your Honor, we have it, and we just need a moment to connect the monitor, and we can bring it in with the jurors once they deliberate.
When you say connect the monitor, so there was some conversation about something in the jury
There is
room.
one in the jury room. If we can avoid having to wait for them to exit, we might be able to use this one, but we will get it done so that when you put them in to deliberate, it will go in with them.
And you've checked it, or you're confident that?
We haven't seen it,
All right.
Show it to us.
Ms. Dunn said there's no internet connection available with that it's just got the evidence, no more, no less. And then we did mention that the physical objects here would also go back, but for the firearm. That's my recollection. Is that right? Am I going to tell them that if they want the firearm, they need to come and ask, or just leave that unspoken?
I think you can, I would tell them if they'd like to see it, they have to ask for it.
All right, okay. So then we got the instructions, everything's good there, so, okay. We'll be back in 12:05, go from there.
I put the period in.
Oh, that's why I asked, because I saw Jill coming in. Okay, good afternoon. Everybody's here, other than the jurors. Deputy Riccio told me that they did place their lunch orders on the written menus that were provided. Once they come in here, he's going to call in the order, and that usually takes, 30, 40 minutes, something like that. So close to the time they're sent out to begin deliberations, the order will be in, and they can, basically, he'll knock, or one of the deputies will knock, present the jurors with the food, and they can eat and deliberate. Yes?
Does Your Honor require that we stay in the building, or can we go down to the, this is
No,
about 2 blocks away?
no, I'm not going to make you stay here, and I'll address that once the jurors are in the jury room and start the deliberations. There's address the attorney's presence, or the need to at least have some contact information, a few other things, but no. You certainly get an opportunity as to get something to eat or stretch or take care of whatever pressing personal business there may be.
Your Honor, the laptop is set, it's been reviewed by the defense, we have the monitor, we can walk it in with, once the jury deliberates, and the clerk has the USB that would have all the evidence, so everything's ready to go.
Thank you. And the defense looked at that.
Yes, Your Honor, he did, and it's fine.
All right, thank you. So when you say we can walk it in, we'll have right. I know that's what you meant, but again, right, I was thinking of the record and, want to elaborate where in an abundance of caution, which is, one of my guiding principles. Sue, bring the jury in, please.
Just one moment, Your Honor.
All right. Deputy Gibb, would you mind giving me some water, please? Thank you.
All jurors present in court, Your Honor.
All right. Members of the jury, please have a seat. Welcome back. Everybody can be seated. Welcome back. So the bailiff informed me that you placed your orders for lunch, and he's in the process of calling that in. They'll be delivered here to the courthouse and presented to you in the jury room once you start your deliberations. So, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. And I'm reading from this packet of written instructions right here. So not only will you receive them verbally from me right now, but this entire package, this very package, will go back to the jury room with you. So you will not only have the verbal instructions, you'll have them in written form as well. Lloyd Preston Brewer, the defendant in this case, has been accused of the crime of first-degree murder. Lloyd Preston Brewer is accused of first-degree murder in count 1 of the indictment. First-degree murder includes the lesser crime of second-degree murder, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Garrett Hughes was killed by Lloyd Preston Brewer, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or second-degree murder, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Number one, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or three, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it is used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Lloyd Preston Brewer may be found guilty of first-degree murder or any lesser included crime. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Garrett Daniel Hughes is dead. Number two, the death was caused by the criminal act of Lloyd Preston Brewer. Number three, there was a premeditated killing of Garrett Daniel Hughes. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If the evidence does not convince you that the defendant committed the main crime of first-degree murder for which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide if the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crime of first-degree murder is second-degree murder. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Garrett Daniel Hughes is dead. Number two, the death was caused by the criminal act of Lloyd Preston Brewer. Number three, there was an unlawful killing of Garrett Daniel Hughes by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and two, is done from ill will, hatred, spite, or an evil intent, and three, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Aggravation of crime by carrying, displaying, using, threatening to use, or attempting to use a firearm. If you find that Lloyd Preston Brewer committed first-degree murder or second-degree murder, And you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm. You should find him guilty of first-degree murder or second-degree murder with a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find that Lloyd Preston Brewer committed first-degree murder or second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of first-degree murder or second-degree murder. Justifiable use or threatened use of deadly force. It is a defense to the crimes of first-degree murder and second-degree murder if the actions of Lloyd Preston Brewer constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. While a firearm is, by definition, a deadly weapon, openly carrying or displaying a firearm and loading it by advancing a bullet in its chamber for use if needed, or pointing a firearm in and of itself does not constitute the unjustified use or threatened use of deadly force. Lloyd Preston Brewer does not have the burden of proving that he was justified in using or threatening to use deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using or threatening to use deadly force. The law on the justifiable use or threatened use of deadly force is as follows. Lloyd Preston Brewer was justified in using or threatening to use deadly force if he reasonably believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to himself or another, or B, the imminent commission of an aggravated battery against himself. If Lloyd Preston Brewer was not committing any crime other than the alleged first-degree murder or second-degree murder for which the defendant is claiming self-defense, and if he was in a place where he had a right to be, then the defendant had no duty to retreat before using or threatening to use deadly force. On the other hand, if at the time Lloyd Preston Brewer used or threatened to use deadly force, he was committing an aggravated assault with a firearm, then the defendant had a duty to retreat. The duty to retreat means that the defendant had the legal obligation to use every reasonable means to avoid any danger before using or threatening to use deadly force. The law does not require the defendant to retreat if he was placed in imminent danger of death or great bodily harm, or imminent danger of the commission of an aggravated battery against himself, and it would have increased his own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if he could have safely retreated but did not do so, then his use or threatened use of deadly force was not justifiable. In deciding whether Lloyd Preston Brewer was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. However, the use or threatened use of deadly force is not justified if you find that Lloyd Preston Brewer used force or the threat of force to initially provoke the use or threatened use of force against himself, unless, 1, the force or threat of force asserted toward the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using or threatening to use deadly force on Garrett Daniel Hughes. Or 2, in good faith, Lloyd Preston Brewer withdrew from physical contact with Garrett Daniel Hughes and clearly indicated to Garrett Daniel Hughes that he wanted to withdraw and stop the use or threatened use of deadly force, but Garrett Daniel Hughes continued or resumed the use or threatened use of force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Lloyd Preston Brewer and Garrett Daniel Hughes. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crimes with which the defendant is charged were committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything, as I previously explained to you. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called upon or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should be considered whether it was freely and voluntarily made. If you conclude that the defendant made the statement, you also must determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to whether, when the defendant made the statement, he had been threatened to get him to make the statement, and whether anyone had promised him anything to get him to make the statement. If you conclude the defendant made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. So here it is. It's 2 pages. It's going back to the jury room with you, obviously, along with the instructions and the evidence. And it's quite self-explanatory in my view, but to be thorough and an abundance of caution, what I'm going to do now is I'm going to go over it verbatim. It's 2 pages. So let's start from the top here. The heading, in the Circuit Court of the 16th Judicial Circuit, Criminal Division in and for Monroe County. So think back to jury qualifications, we all talked about everybody had to be a resident of Monroe County, and I told you that's because this is the jurisdiction. Well, there it is, right at the top of the verdict form. Then, right beneath that is what we call the style of the case, and you've heard me recite that numerous times. State of Florida plaintiff versus Lloyd Preston Brewer, defendant, case number 2023 CF 00070AK. And then below the heading and the style is the title of the document, verdict. And it begins with the proclamation, we, the jury, find as follows. All right? As to count one, we find the defendant. So there's options here. And I'm just going to go over this right from beginning to end, by no means suggesting what your verdict is, just explaining it as it's laid out here. So, if your verdict as to count one is guilty of first-degree murder as charged in the indictment, your foreperson would put a check mark on that line, that blank line ahead of that verdict. And then you would look right beneath that. If you find the defendant guilty of this offense, you must answer the following questions. So if you find the defendant guilty of that offense, then you've got to answer these specific questions. Number one, did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes or no? If it's yes, check mark in that line. If it's no, check mark on that line. Going down to the next question, did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes or no? 2 lines. One of those, if you get to this point, would be where the check mark would place, depending upon what your finding is. And number 3, did the state prove beyond a reasonable doubt that the defendant in discharging the firearm actually caused the death of Garrett Hughes? Yes or no? Once you finish those 3 questions, if that's your verdict, you go to the second page. It says, so say we all, this being the 21st day of January of the year 2026, Key West, Monroe County, Florida. Your foreperson would fill in that date and then sign the verdict form right above on the line above the name jury, foreperson signature, and print his or her name right below that. So, continuing, if the jury's verdict is guilty of second-degree murder, a lesser included offense, well, there's a line ahead of that option, and obviously, if that's your unanimous verdict, that's where the check mark goes, and once again, you would then follow the instructions. If you find the defendant guilty of this offense, you must answer the following questions. 1, 2, and 3. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes or no? Check mark in the appropriate line. Number 2, did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes or no? Again, check mark on the appropriate line. And number 3, did the state prove beyond a reasonable doubt that the defendant in discharging the firearm actually caused the death of Garrett Hughes? Once again, check mark either on yes or no, depending upon what your finding is. And then the foreperson would date, sign his or her name, and print his or her name in the appropriate space. And finally, if your verdict is not guilty, then there is a line ahead of that verdict. That's where the check mark goes. And once again, the foreperson dates, signs his or her name, and prints his or her name at the appropriate lines. So that's the verdict form. In just a few moments, you will be taken to the jury room by the bailiff, court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. So the foreperson, I always say, just fold it in half, bring it back. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. And I'm going to talk a little bit about that in more detail in a minute. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. So here's how we're going to do that. There's a laptop and a monitor, and there's a thumb drive or a disk, whatever it is that has all these exhibits that have been admitted into evidence, and some of them have been published, some of them haven't, but everything that's in evidence is going to be on that laptop. There's no internet connection. There's nothing else there. You're going to have the drive or whatever you want to call it. It goes in there and right there for you. In addition, the physical exhibits. There were some physical exhibits that were admitted into evidence, that were published, that were mentioned in argument. Those are going back with you to the jury room as well. The only exception is the firearm. That's going to stay out here. If you would like to view that, see that, you'll give a note to the deputy. I'll explain that, and we'll accommodate that. But everything in the forms that I've just mentioned is going back, so you'll have both the written instructions as well as all the evidence to use during your deliberations. If you want to see the firearm, tell me. We'll accommodate that. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So I'd like to ask the lawyers if they would approach the bench here just momentarily. This is one of my least favorite parts of the trial because I have to excuse the alternates. The Yeah, I know. We talked about this during jury selection. You may recollect that one of the jurors indicated they'd served as an alternate, and I took that opening to explain why an alternate was so important and why it's a tough job and a necessary job. So in this particular instance, Ms. McDowell and Ms. Baldwin, you've served admirably. You've been here on time, attentive, listening, just done everything I would ask of you and more. And now I'm sure your mind is full of law and evidence and ideas and thoughts, and I have to deprive you of the opportunity to deliberate with all your fellow jurors because they're all here. Oftentimes that's not the case, especially when we have so many jurors. For one reason or another, sometimes one or more of them cannot continue through the end. If that happens, the alternate can actually take their seat and we can keep on going. Otherwise, there has to be a mistrial. So that hasn't occurred here, so I thank you ladies profusely. Certainly you can remain and have your noon meal when you brought when it comes, but you can't deliberate or be in the jury room with the fellow jurors at this point. But with all our sincere thanks, thank you. And Deputy Review, if you would escort the alternates to the jury room, let them retrieve their stuff, tell them how they can get their meal, and we'll go from there.
Yes, sir.
Sorry, ladies. Thank you so much. A few more things while we're waiting for the alternate to clear the jury room. You've heard me talk about electronic devices and cell phones quite a bit. So obviously that tells you how big a concern it is and how it's absolutely antithetical to justice in the case or the rules and instructions to be employing those devices during your deliberations. To such an extent that the Supreme Court, not yours truly, but the Supreme Court of the state of Florida says they cannot be accessible or available to jurors during deliberations. So, we here in the 16th Circuit have found it preferable, instead of having you all leave your devices there in the chairs, and not that I think they'd be compromised in any way, shape, or form. I have eminent faith in our security, but just I think it's more comfortable to do it this way. When we go in the jury room, the bailiff is going to ask if any of you do have devices, if you, whatever type, to produce them, and there's a lockbox, and it's right there, and he's going to collect them and put them right in the lockbox in front of your very eyes, so then they can be secured, and there they'll stay until you're finished. That way, you know they're not being compromised, you know where they are, so I think that's a better way to do it. And if for some reason you need to make a call, I'm going to explain how we do that as well. So first of all, you can bring your notepads back with you now. Up to now, you've had to leave them out here, but now you want to use them, any notes you may have taken during your deliberations, you can do that. It also serves the dual purpose of being able to communicate with me through a written note. If there's some question or problem that somebody has to make a call, your foreperson should take a clean page from his or her notepad with no notes or any markings on, just a clean page, and neatly, completely, and legibly, so I can read it, put down whatever the question or concern is, fold it, or the foreperson should sign it, so I can find out who it is, fold it in half, knock on the door, give it to the bailiff. Here, this is for Judge Jones. Bailiff will bring it to me, I will look at it, then I will share it with the attorneys in the presence of the defendant, and I will decide how to address whatever the concern is. So that's the procedure that we're going to use for that. So I think I've covered everything. So, ladies, gentlemen of the jury, you may now retire to consider your verdict. Right, so the jurors are outside the presence of the courtroom here. Let me just address a few details. Number one, we've already talked about the laptop and the exhibits, but for the firearm. So just in an abundance of caution, the clerk, you've got all that together, right? And so the lawyers, once I step down, if you would just check it, an abundance of caution, just to be sure everything that needs to be there is there, nothing that shouldn't be there is there. Could be okay, bailiff is going to take it back, knock on the door, here you go. Number one. Number two, question about having to stay here. No, I would suspect that the deliberations are going to take some time. You don't have to stay in the courtroom, but you do have to have a number and provide that to the clerk, the bailiff, and don't be too far away. But certainly, if you want to get something to eat or whatever you want to deal with, that's fine. But if the jurors have a question, if there's a problem, if there's a verdict, we're going to reach out and contact everyone, so then we can all reconvene and on the record address whatever the situation is. And finally, I just want to say this. I want to commend the attorneys for both sides. It's not easy to try any case, let alone a case with this type of charge, with this type of visibility. That's one of the hardest things in our profession, frankly, and I want to commend both the state and the defense counsel because you've conducted yourself very effectively, very professionally, ethically. You've certainly represented your respective sides as zealously as the law allows. So we all done this enough to know you can't predict what a jury's going to do, but from my perspective, I commend you and say it's not for some deficiency in any kind of legal advocacy that a particular result was reached. So, and that's how I see things. So I'm going to step down now, check out the evidence, and prove it, and I'll be available when needed. Okay. Okay, good afternoon. Looks like we have the defendant, defense attorneys, prosecutors, court personnel. So I've been advised that the jury's reached their verdict. So let's bring them out, please. Thank you. Members of the jury, please be seated. Welcome back to the courtroom. Mr. Foreman, I see, or I've been informed that the jury has reached its verdict. Is that right? That's correct. Would you be so kind as to, looks like the form is folded, if you'd give it to Deputy Riccio, he's going to give it to me. It's my responsibility before it's published to be sure that it's in proper legal form, so that's what I'm going to do. It is in proper legal form, so I'm going to ask the defendant counsel to please rise. All right. Madam Clerk, would you please publish the jury's verdict?
In the Circuit Court of the 16th Judicial Circuit, Criminal Division, in and for Monroe County, case number 2023 CF 70 AK, State of Florida versus Lloyd Preston Brewer. We, the jury, find as follows. As to count one, we find the defendant guilty of first-degree murder as charged in the indictment. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant, in discharging the firearm, actually caused the death of Garrett Hughes? Yes. So say we all, this 21st day of January 2026, in Key West, Monroe County, Florida. Four-person Eric drove.
Be seated. Would either the state or the defendant desire the jury be polled?
Yes, Your Honor, please.
All right. Madam Clerk, would you poll the jury, please?
Yes. Timothy Brady, is this your verdict?
Yes.
Eric Droff, is this your verdict?
Yes.
Wayne Smith, is this your verdict?
Yes.
Lori Maciosi, is this your verdict? Yes. Timothy Watson, is this your verdict?
Yes.
Whitney Hale, is this your verdict? Yes. Jessica Schreitmuller-Keppel, is this your verdict?
Yes.
Mary Ann Johnson, is this your verdict? Chase Spieldenner, is this your verdict?
Yes.
Philip Welsh, is this your verdict?
Yes.
Jessica McKinney, is this your verdict?
Yes.
Aaron Rust, is this your verdict?
Yes.
Then let the verdict be entered and recorded. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss your verdict or your deliberations may come from those who are simply curious from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. So that concludes my formal instructions to you. Again, as I've said throughout, I've expressed my appreciation and my comments about your attention, your patience, your timeliness, your service is greatly appreciated, and I thank you. So with that, you as a jury in this case are now discharged, and Deputy Riccio will escort you to the jury room, and thank you so much, one and all. There we go. Jurors are gone. We can all have a seat. There's a couple other matters we need to address. I think we're going to be doing a sentencing hearing right now. I would believe that needs to be set sometime in the future. So I also believe we should, but maybe it's a moot point, have a pre-sentence investigation. But again, I'll ask the lawyers if you're interested in a PSI.
I think that's appropriate under the circumstances.
Yeah? All right, so we're going to request a pre-sentence investigation from the Department of Corrections. Normally, they like to have 30 days lead time for preparation. So sometime thereafter would make sense to me as to when we would set a sentencing hearing. And in addition to the date, about how much time would we want to set aside for that proceeding? An hour? Is that adequate?
That seems to be appropriate. So it may change depending on when we see the PSI, but that's...
Well, okay, an hour and a half. I mean,
That's fine, Judge.
all right. So I would like to designate the date and time now, if possible. Like on Wednesday, February 25th, I already have a sentencing on that day in another case set for an hour in the morning, so that date's available. You're involved in that one, Ms. Dunn. So I have that date. I have the afternoon of the next day, Thursday, the 26th. So those are two that are within the time period I would think would be appropriate, but I don't know what availability is. I have that Monday, the 23rd, but I have jury qualifications that morning, but I don't have any jury trials, so I'm floating out the 25th, the Wednesday, 10:30 in the morning or 1:30 in the afternoon. I'm suggesting the 26th at 1:30 in the afternoon. I don't know what.
Judge, as far as the defense is concerned, either the 25th or the 26th at 1:30 would be preferable.
Whichever the court prefers, Your Honor.
Well, I would say if it's going to be up to me to finalize it, I would say the 26th at 1:30 in the afternoon. That way we don't have to address two major matters on the same day, for whatever that will provide. So it's February 26th, 1:30 in the afternoon for 90 minutes, requesting a pre-sentence investigation. At this point, again, might be moot, but we're going to withdraw or vacate any bond conditions, and the defendant's going to be held without bond. So Unless there's some other matter to come before the court at this time? Right. All right. Court will adjourn.